unring the bell, unwind the clock over the course of 72 hours over the weekend, we think is severely prejudicial. So we have laid out a menu of options for the court in our request for relief. We believe that this was options for the court in our request manipulated, intentional, contumacious, by clear and convincing standards for the court in our request. Manipulated, intentional, contumacious, by clear and convincing standards for the court in our request. Manipulated. On his computer. In essence, there's no way that as we were proceeding through this case, defense counsel was unaware or forgot about all of these systemic, cultural, and retaliation issues that were at the forefront in 2018 and 2019. We believe that conduct is severe enough to warrant the striking of defendant's answer and proceeding this morning on damages.
Wow, that's a lot.
If the court thinks that's too
So what
severe,
is this now, a 53rd motion for summary judgment now we're doing?
Given the history of this case, having been up to the Second District Court of Appeal, that the court should direct a verdict on punitive damages if the jury, after deliberation, believes that we have proven battery or false imprisonment, the counts that are subject to punitive damages. We have been unable to develop the evidence on that over the course of the past 5 years, given the withholding of information. Third, if the court believes that is not appropriate, we have suggested, and it sounds like the court may have weighed into these, so I heard something about potentially a directed verdict on negligent training. We think that could be an appropriate sanction. Third, and in combination with others, striking the testimony of Mark Anderson and giving the jury an instruction to that effect that his testimony was unreliable and misleading because even from him, material and relevant evidence was apparently withheld. Fourth is what the court suggested a moment ago, that we proceed this morning, we cobble together, and we have prepared an exhibit list, if that's how we do this today, with some of the more critical documents that we received on Friday evening. And we put Dr. Corcoran back on the stand, and he has the ability to talk about these issues and how they affected the hospital in 2016 and 2017, the time of my admission. And fifth, regardless of what the court finds appropriate from what we've presented here, sanctions against the hospital, attorney's fees for all these efforts, taking the deposition. I don't know how far back that.
I am just watching the live feed.
Those are our suggestions to the court.
Okay, thank you.
Good morning, everyone, by the way.
Please, court. I'd like to address first Your Honor's question regarding how we proceed this morning and what's necessary to proceed this morning. And in order to do that, I need to make clear to the court most of the information that was set forth in our filing on Friday of Angela Green's affidavit, as well as the disclosure that we filed. If you go back and you look at Dr. Corcoran's testimony.
Can I ask a question, though?
Yes, sir.
So you file Ms. Green's affidavit and you file a motion for clarification, and then none of those.
I feel fine. Thank you for asking. I'm on a remote setup, so my mic isn't quite the same as it normally is. So that might be part of the reason.
The actual.
You know, I'm not at my home setup with my nice mic, so.
From your affidavit.
We got a little lavalier mic, which isn't quite as good, but I feel
The
great.
affidavit, well, first of all, the immediate jeopardy finding was in a letter dated 1/31/19, and that has been provided. But
it was not sent to the court as part of the affidavit. It wasn't part of your motion for clarification.
It was not.
I mean, you attached a whole bunch of other things saying how wonderful everything is, but you didn't attach that.
Yes, sir, because the point of the filing was that the immediate jeopardy finding was immaterial and did not relate to the period of time that Maya was in the hospital.
So when I said to turn it over, you didn't immediately turn it over to the plaintiffs. You didn't even attach it and send it to the court. I mean, what am I missing here?
I think you're missing, Judge, what we're trying to get across in terms of what brings us here and what the real point of Your Honor's order was and what the real point of the testimony at issue here is.
So when I say to turn over the immediate
I
jeopardy
can turn up the
finding,
volume on my end a little bit too.
you're going to interpret that not to turn over the immediate jeopardy finding?
No, sir, Your Honor, we turned over the immediate jeopardy
When?
finding. By Friday morning, I have a list here of about 30 or 40
I'm not sure if I can
different
make it any louder,
documents that we had
actually.
turned
It
over
must
to
be
the
the way where I
plaintiff
produced it.
in less than 48 hours after this all occurred. I've also got, since then, a list of about 170 others. We've provided nearly 1,500 pages of documents that include the immediate jeopardy finding. Counsel interrogated Ms. Green in her deposition
Turn down the volume
regarding
of
the
the
immediate
YouTube a little
jeopardy
bit so
finding.
the mix will be a little bit
And the immediate
better.
jeopardy finding, as she explained, was based on a site visit that the CMS did in January of 2019. If you read the report of that, which she testified about, you will find that all of the information that they gathered and all of the conditions that they addressed were set forth in that letter and related to that time frame. There was no,
When I went to look to actually read the immediate jeopardy finding, you didn't attach it. So how am I supposed to read it if you didn't attach it?
Judge, my apologies
Burn.
for not attaching it, but again, the point of the affidavit and the point of our filing was to attempt to clarify the basis on which there was any suggestion that the immediate jeopardy finding was relevant to the hospitalization here at issue. What I was trying to get across to Your Honor, obviously unsuccessfully, is the fact that the premise of Dr. Corcoran's testimony is based on two things. One is that the immediate jeopardy survey took place in September of 2018 and was a, quote, look back, unquote. First of all, there was no survey in September 2018. And secondly, the surveys don't look back, they look forward. And that's the second point of the filing. It was to establish the fact that at the time of Maya Kowalski's hospitalization, what Dr. Anderson, or Mr. Anderson testified to, witness Anderson testified to, was that we were in good standing with JACO and CMS. The point of the filing was that we documented that that was in fact the case.
Dance harder, baby.
Certificates had been issued in
Dance harder.
2015 and in August of 2018, indicating that we had been reaccredited and that accreditation, barring any other activity and barring any other violation, was good for 3 years. The period of time that was covered by Mr. Anderson's testimony, Ms. Kowalski's hospitalization, was in the fall of 2016. During that period of time, we had been accredited by the Joint Commission, and we've got copies of the certificates we've provided. They're attached to the motion. The point is that the entire premise of this, that the immediate jeopardy finding was somehow related to the status of the hospital.
Thank you, Bri, for the super chat. Good morning.
Hospitalization is simply not true. There was not.
If I was thinking about sanctions, I'm like, if you haven't given me the reports, I'll deem it all as admitted.
The immediate
You're not
jeopardy
following
did
my
not
order
base its findings
at this
on
point,
anything that
right?
took place during Maya Kowalski's hospitalization or that was even reviewed at that time. The point we were trying to make.
You can't give orders unless you're prepared to follow through.
That Mr. Anderson's
Like a
testimony,
parent
however
with a child.
brief
You don't make threats
and
unless you're
however
prepared to follow
summary,
through.
was simply correct to the extent that we were, in fact, accredited at that time and that there was nothing untruthful or misleading presented otherwise to this jury. That was the point we were trying to make.
Was there a culture? Did any governmental agency or the Joint Commission talk about a systemic failure of the culture at the hospital?
There was a discussion of that finding. There was a discussion of
So yes.
failings of plans that took place in January of 2019 that did not relate to anything that was occurring in the fall of 2016, 2.5 years earlier.
How do you say that? I mean, am I just to take your word for it? I mean, how do I know that when the plaintiffs just told me they got evidence of systemic problems, which apparently Ms. Green talked about in her deposition?
Your Honor, with respect, Ms. Green talked about in her deposition findings that were made at the IJ in January of 2019. If you look at the report that resulted in the IJ, it's a report from CMS that has been provided.
Your Honor, it's okay. We might have had
indicates
systemic issues, but it wasn't
basis of the
exactly
IJ
when
was.
Maya was there, so
And
it's
it
not that
talks
big a deal.
about interviews,
The
and
fact
it
that we're a
talks about
hospital that just,
evidence
is
that was
being blasted
gathered
all
in
over the
January
page is
of
not that big a deal
2019 during a
because
site visit
it wasn't
between
happening
January
exactly when
7th and
Maya's there,
January
so
11th
it's
of that
fine.
year. And then it relates some of those failings to its interpretation of policies that were adopted in September of 2018. None of that reaches back the preceding 2 years to when Maya Kowalski was a patient. The whole point of this is, the whole premise of Dr. Corcoran's assumptions, and it was an assumption. He looked at that report, he saw the date of September 20th, 2018, and he assumed from that there was a Joint Commission survey at that time that resulted in an IJ. That's been proven to be incorrect. And also it's been proven that was not a look-back situation. So the whole premise of this, the whole point of this.
Look, here's what I'm
is
thinking
not
of.
what was
Here's what I'm
going
thinking
on
as
at
the
time of
judge
the
right
IJ
now. I'm thinking,
and the findings
did I
that
give
were
an
made
order?
regarding the IJ
Have you followed
in
the order?
January of 2019.
Right? If they haven't followed the order,
The point of this case
I'd be
and the
really
things we're trying
mad.
to litigate here took place in the fall of 2016, 2.5 years before. And there is not anything that has been produced that I'm aware of that relates the IJ or its findings or its basis to what was actually happening on 7 South or 7 North where Maya Kowalski was a patient
Wow.
in 2016.
Slice that thinner, counsel.
Proof that
Slice
we
that
put
thinner.
forward in Angela Green's deposition, and she's here to testify if need be today, Judge. The proof that we put forward, simply put, was that the IJ related to the self-report of the Heart Institute and the Heart Institute alone. If you look at the report, if you read the report itself, you see talk of governance, you see talk of infection
I tell you
control,
what, as
see
the judge
talk
right about now, all I'm
contractual
hearing is
duties,
the
but when
teacher
you look
from
at what the
Charlie Brown in
interviews
my
were,
ear.
in each
Wah,
item
wah,
of that
wah,
report,
wah,
it talks about interviews
right?
that were conducted
You have long
in
since passed the
January of
point
2019,
where
and
I was
findings that
paying
were made
attention.
in looking at documents at that period of time or over the preceding 4 to 6 months.
'Cause I'm like,
It
did
says
I stutter?
nothing about looking back 3 years or 2.5 years to this period of time.
Johns
because
Hopkins
it
Hospital
simply
right now is
didn't.
going with the philosophy,
Ms. Crane
as long
lose
as I
her
keep
job
talking,
because
you
of
can't
this
rule
issue?
against me, right?
Ms. Crane
We're gonna
lost
try
her
to
job
filibuster this.
because of the
Sure.
Heart Institute issue and the failure to report deaths and the failure of oversight regarding those issues. If you look at this, Judge, I apologize, Judge, but I didn't mean to cut you off, and I want your questions. I really do.
Here's my question. Did
The
I
point
give
of
an
this
order?
is, however, that
Have
if
you
look
followed
at
the order?
sequence of events
Those
here,
are my questions.
there was, in fact, a self-report to the Joint Commission. It was oral, and then it was supplemented with a written report. The other two reports
The
were
self-report occurred because there was a media report out there already. Is that correct?
That is true, but there had been reports and there had been discussions beforehand.
Well,
There,
wait a second. Did the hospital report to whether it's the Joint Commission or any governmental agency prior to the media outing the hospital on the issue?
There was a report
Yes was the
and a
answer.
review that took place in the spring
Thank you, Brian, for the gift
of
memberships.
2018.
A report. a report? Who's reporting what to whom?
There was a media report then regarding a heart case that was reported by the hospital to the Joint Commission. I believe, I don't have it right in front of me, I believe there was also a report to ACA and or CMS. There was a site survey that took place at that time. There was a review done, and there was a follow-up. And the deficiencies were cleared. There was, in addition to that, the entire triennial survey, which took place in August of 2018. Those documents were attached to the motion. There was none of these deficiencies found or identified at that time. So what happened here was there was concern regarding the heart program. There was an effort to address that. The regulatory authorities came in. They did a survey. They found the deficiencies.
I would have, as a
addressed.
judge, told him
There
to
was a
stop
subsequent
talking long
triennial
ago.
review in August of 2018.
I would have literally said, stop talking.
That
Let's make this
resulted in
simpler.
a reaccreditation
I gave an order.
that renewed
Have
the
you followed it?
accreditation that was in effect at the time Ms. Kowalski
all
was
I
in the
wanna know.
hospital in from September of 2015. So at the time of her hospitalization, the hospital was in fact accredited by the Joint Commission. It was in fact accredited and in good standing with CMS. There was no indication otherwise. Those facts were reaffirmed in August when there was another triennial review. When this hit the fan, so to speak, with the media report, that was self-reported. That was self-reported that day. And 2 weeks, 3 weeks, nearly a month later, CMS came in with an unannounced survey and made their report. They left. They did not find an IJ at that time. They issued the IJ on January 31st, 2019. We had 10 calendar days in which to respond. We responded. There's all this correspondence has been provided. That the issues that were raised in the IJ, according to what we sent to them at the time, correspondence from one of our senior officials, said basically, here's the plan we had already put in place by the time of the report. Changes were already underway. Here's the plan we had already implemented. Then, in addition to that, there was a proposed plan of action to address the IJ and address the deficiencies. That document was provided. Then there was another on-site visit that took place in February 20th and 23rd, I believe, of 2019. That resulted in the IJ being lifted with a plan in place that we had to abide by. We abided by it. There were subsequent follow-ups, and it was cleared. But the IJ was lifted, Judge, in February of 2019 by CMS. And obscured in all this is the fact that at or about the same time that CMS was conducting its follow-up survey regarding the IJ, the Joint Commission was also in to do a follow-up review, and that was cleared. There were no deficiencies found. And so what I'm trying to get to is this, and the point where we can show you what happened with the IJ, we can demonstrate all that, but what I don't want to get lost in all of this is this central bottom line fact. The issue that brings us together into this conversation today is the question of whether Mr. Anderson's testimony about the standing of the hospital regarding JCO or CMS, whether his testimony was incorrect or misleading. And the answer to that question is that it was not. And there's no basis, there's no indication in the record otherwise. All you've got to suggest otherwise is testimony that is based admittedly on supposition. Okay? When Dr. Corcoran testified, he indicated that he had never seen a Joint Commission document regarding an IJ. He had never seen any indication that there was in fact some survey in September of 2018, and that's for good reason. There wasn't one. And the point that I'm trying to get across to Your Honor is that at the time of this hospitalization, there was in fact a certificate issued that had been issued that had never been revoked and never been abrogated, that Johns Hopkins All Children's Hospital was accredited by the Joint Commission, and there was no indication from CMS otherwise.
So what is your suggestion, your game plan for today?
My suggestion, Your Honor, that if this issue is that problematic, that the jury be instructed to disregard Mr. Anderson's testimony with reference to JACO and CMS, and that we proceed.
You want to strike the testimony of your own witness? Is that what you want to do right now? Wow.
We believe
I don't know.
this entire issue.
I'm trying to remember if I've ever heard that one before. That's a good one. Okay, if this is really a problem, Your Honor, what we'd really like to do is unwind the clock. Let's just give a motion. Let's just give an instruction to the jury to completely disregard our own witness testimony. Let's pretend it never happened. If it's that big a deal, we'll just strike their testimony completely and we can move on. I love it. That's good shit, man.
Any prejudice far outweighs the probative.
Wow, that's a good one.
We've been litigating and investigating a purely collateral matter. And Judge, I think we're at a point where the best and most conservative management of this situation is to proceed. And if there is some
a motion for a mulligan, that's a fun one. I like that. That's good.
The need to address and rebuttal, then let's do that. But I would implore the court to look at the circumstances and look back de novo at what Mr. Anderson
I also like
said,
earlier that they said that their own witness did nothing wrong, right? Our witness was completely truthful on the stand. Everything they said was fine. There's no contradiction in the record. There's no suggestion of a contradiction in the record. Also, if there's a problem, we can just strike the testimony completely.
We're going off into a collateral matter that is going to be fundamentally confusing.
I've heard about arguing in the alternative, but man.
Prejudicial, and if we go down this road, we're going to have more problems than we could possibly imagine.
So when witness Mr. Anderson is asked the following question, let me talk to you about your overall view based on what you've reviewed. Did it appear to you, based on the materials you reviewed, the records, the policies, that all Children's Hospital had an appropriate safety plan in place for patient care? Answer: yes, they did. So,
Your Honor?
So I mean, that is something that the hospital adduced in front of this jury.
Yes, sir. And at the time.
Now you're telling me the door was not open.
Well,
I mean, that's what you're telling me?
What I'm telling you, Judge, is two things. Number one, if he were to be called back, if we can get him back.
Oh, you'd like to reopen direct.
The proof would be that at the time that he referenced that statement.
Your Honor,
as of
our witness misspoke on the stand. We could just get him back on the stand. We could clarify
Joint
this.
Commission on the Accreditation of Hospitals had reviewed the safety plan in effect in 2015 and issued an accreditation based on that. And there's a certificate to prove it. And then
let me cut you off. Did you even provide witness Mr. Anderson with any of this information that we've been discussing since Wednesday afternoon? Was he provided any of it?
yes, sir. We sent.
He was provided the information? Because we had an issue with what was produced to Mr. Anderson, witness Mr. Anderson. So I want you to be very clear as to what was specifically produced to witness Mr. Anderson. Very, very specifically.
Since Wednesday.
Since Wednesday, we've given him information. Oh, so he didn't have it when he testified.
Since Wednesday. At the time
Yeah,
he testified.
that's right, Judge. You tell him.
Had the
You tell
defense
him.
even provided any of the information that we've been discussing since Wednesday?
May I ask Mr. Shapiro to address that, Your Honor?
Mr. Shapiro, do you want to step into the breach here?
The answer, by the way, is no.
Only to the extent that he was provided hospital policies and procedures, yes, sir.
That doesn't answer my question.
Yeah.
No, it doesn't.
I did not provide him Joint Commission surveys.
There's the right
So I
answer.
don't
Good
know
job.
if you looked at anything online, but to my knowledge, no.
Good job.
My understanding of his just to explain, my understanding of his testimony, Your Honor, is that the fact that the hospital was able to operate at that time meant that they had gone through joint accreditation surveys. That was the simple basis of his statement that he volunteered.
Didn't even provide the information. Okay.
That's the smile of you're fucked.
I just point out to the court that we have been scrambling very hard to try to provide as much information as quickly as we can. And
I'm sure.
I
I'm
believe
sure.
that this
Since
issue
Wednesday,
can
we've been
be
trying to provide
addressed
so much information.
either with an instruction, a
This
curative
trial's
instruction,
only
or
been going
some
on since Wednesday, after all, Your Honor. Wednesday was the first time we ever heard of Maya Kowalski.
disposition.
How could we
I think
possibly
if
have been
we go
expected to
full scale
provide it
into
in such a
we're
short
opening a whole
interval?
nother trial.
Well, plaintiffs are telling me that if I don't go into it, I'm getting another entire trial anyway. Okay, we are where we're at. Anything else, Mr. Hunter, that you would like to say before I let Mr. Whitney have a very brief rebuttal, and then we'll talk about what we're going to do.
I don't believe so, Your Honor.
Great. Yeah, you have
Whitney,
nothing left to say,
very
do you? You know it's over. All right, don't screw this up. The judge already wants to rule for you, so you don't have to oversell this. So don't screw this up.
I need to dispel a couple of notions. First, that these issues were limited to 2019. In what was produced to us Friday evening during the deposition, we have an ACCA statement of deficiencies dated February 23rd, 2017, specifically for risk management deficiencies. The specific violations relate directly to patient rights, coordination of care, and patient-family education. That was less than 1 month after Maya Kowalski was discharged. We provided that the first time from ACCA on Friday afternoon. The statement of deficiencies and the corrective action that we were provided. Mr. Hunter just represented this court that surveys don't look back, they look forward. That's absurd. They have to look back, and in the corrective action plan,
that's difficult.
page,
Looking forward
I don't know
is
what page. I can pull it from
difficult.
Court
That's where you break out the
Patient Safety
soothsayers
Committee
more.
reported 12 retrospective Code 15s and additional Code 15 reported during the required time frame. They're not talking about the future. They're talking about the past. Ms. Green confirmed that in her deposition. In the corrective action plan provided Friday afternoon, the risk management department was not included on the organizational chart included in the quality and safety plan. There was a failure to have them report to the medical executive committee, the president, the board, or the integration of risk management into the hospital organization structure and quality assurance program. There was found to be, retrospectively, no evidence of risk management reports or data collection in the past 15 months, and no historical data related to objective indicators of quality, all retrospective. The failure in the plan of correction, the governing body failed to ensure management of the organization. That's how that begins. The interim president accepted the resignations effective immediately from the president, vice dean, the VP chief of staff functioning as lead executive of risk management, the chief patient safety officer, and the VP of marketing and communications and culture. The director of risk management was replaced by someone in the role of vice president of medical affairs. Mr. Anderson's testimony.
I haven't heard them discuss the juror yet.
Exchange about patient care. This goes directly to patient care. The last thing I'll say, Your Honor, is that we've been at this for just under an hour, and we admit that this is a lot to put before the jury on the final day of what's supposed to be the final day of this case. For that reason, we think directed verdicts are the most appropriate way to deal with this. Rather than bringing in Dr. Corcoran, introducing 15 documents, bringing in Mr. Anderson back, they want to bring in Angela Green now, and have a mini trial on this issue. We think directed verdicts are the appropriate remedy.
You're not going to get it. I appreciate your ambition, but no. but you will get whatever, that you will get the documents in. We can extend this trial another day, I guess.
Question of sanctions filed by the plaintiffs against the defense. Ultimately, I'm going to be reserving on the question of sanctions. That's a bigger issue than what we have time to address today. And there's a lot of concerning issues that we'll ultimately have to work through. I need to address where we are right now, what we should do and what we should not do. I've got a situation where the defense knowingly and intentionally presented evidence to this jury that everything was fine about at the hospital at the time of Ms. Kowalski's admission.
Yeah.
There is evidence out there that can be viewed that there is a systemic culture of problems, especially centered in the risk management department. Now, absolutely, without a doubt, it does seem that the driving force was this Heart Institute issue, but there is a view of the evidence that plainly and without interpretation could be seen as being more pervasive than just isolated to the Heart Institute. That there's a view of this evidence that it is systemic, and systemic means systemic. And when we talk about culture, and I hear what the defense, they want to view, well, look, this happened in 2018/2019, so you can't look back. Culture, however, is not something that you just turn on and turn off. It's not like a light switch or buttons on this wall that I can't figure out how to turn on and turn off lights. But it goes to the essence of what an organization is. And that takes time. And a 3-year look back from a time that we know that it was spotted by regulators, both governmental regulators and otherwise, suggests, or at least there's a view of the evidence that a jury could find that this pervasive culture existed at the time of Maya Kowalski's stay at Johns Hopkins All Children's Hospital. You know, this culture might even go all the way back to the time of Johns Hopkins' purchase and acquiring of the hospital, which was, I think, 2011 or 2012. So I now have a situation where the defense presented everything is fine. And I think it's appropriate and required for the plaintiffs to rebut the evidence that the defense presented to this jury. Now, that being said, this is not a deep dive into what happened in the Heart Institute, what happened everywhere, but it goes more broadly and more high level as to what the culture was and the problems that existed, what appears to be admitted by Johns Hopkins All Children's Hospital. And I think if the jury hears that at the high level, that is an appropriate response for the plaintiffs to rebut.
Yeah, I like that.
The defendants presented, and then we'll let the jury make the decision as to whether it's relevant or not relevant. I don't think we need to get into a situation where we have, 14 days of testimony as to what happened in the lead up to, okay, you can call them self-reports, but if they happen because the media outed you, I'm not sure it's a self-report. Be that as it may, we'll call it a self-report. So I do think that there is a way we can proceed. So this is what I would suggest. Apparently there's 2 more boxes of materials. I see the plaintiff has his expert here that you spend this morning going through the documents and let the expert come on the stand and testify at about 1:30 today. Hopefully we can finish the evidence. And then I can give jury instructions this afternoon and the parties can do closing arguments first thing tomorrow morning.
That's ambitious, but okay.
So, Mr. Whitney.
I was only going to,
Thoughts?
yes, I was only going to say, I think there's a lot of those boxes, but we're not going to be able to have time to explore all of that. And I think we have an hour and 20 minutes left in our rebuttal. I think our preference would be to, with what we have here, there's enough to put in front of him to discuss this at a high level now.
Strike his testimony.
Right now?
And,
As counsel said.
And the other remedy, of course, striking Mr. Aaron's testimony. But in terms of timing, that's what I'm speaking to right now.
You don't want to strike his testimony.
We prepared an
It is the
exhibit
basis
list
for all this.
with 5 or 6 of these critical documents. We can get the issue in front of the jury for rebuttal this morning and hopefully wrap this thing up.
You want to call it now?
May I be heard for just one moment?
No,
Since
absolutely
I'm
not.
delivering the closing. Judge, we can't unring that bell unless we strike the testimony of Mark Anderson. If the court recalls, juror number 1 asked a question which reaffirmed their point about whether the government had passed judgment or had accepted, or whatever you want to call it, approved of the actions of Johns Hopkins, that there were no problems.
Your motion to strike is a funny,
You can't
funny joke,
unring that
counselor.
bell unless
Funny
you
joke.
do something to let the jury know
Neither
that
the
that
last
was
this
highly
morning.
questionable testimony. Because even if we come back here with some rebuttal, it's still in the jury's mind that the other guy said, well, but the government overall, they found that they were okay. Yeah. And I know juror 1 at least, who's asked the most questions, has been, I mean, it was a concern to him. So we move the court to strike all or the significant portion of expert Anderson's testimony.
No.
Or else we have an incredibly uphill battle.
Yeah, that's a you problem. You do. That's a you problem.
Well, you know, I hear Mr. Hunter, he's making a full-throated argument that what happened in 2018 has no bearing going back. And, you know, if that's the argument he wants to make to the jury, then why should I preclude him from making that argument and presenting evidence to that effect?
I would stop entertaining this long ago.
Don't say that he can't make some sort of argument. I'm saying
Please
that
stop
the
talking, counselor.
particular phrase
It's over.
that there was the
We're moving on to the other thing.
Passed, approved, and I forget
Come
the
on,
exact
Judge,
quote
take
that's in our
control.
memo.
Take control.
Johns Hopkins, during this period, be
I
stricken.
ruled, sir.
And then, however he wants to argue the rest of the testimony from there, fine. But the key point is, for those jurors, that the federal government had passed on the conduct and the management of Johns Hopkins. And that is at the core of our case, particularly punitive damages. So if we cannot get that out of the jury's mind, because let's face it, it was procured.
Thank you, Tammy, for the 10 gift memberships. Appreciate it.
Lack of production to us.
We
and
appreciate
some
everyone who
highly
supports the
questionable
channel.
representations.
Thank you.
If at the time we had that stuff, we could have attacked it and we could have done something about it. We did not have that option. The testimony needs to be stricken for us to have a level playing field.
No. You can't strike the testimony.
Well, if
Absolutely
I strike
not.
the testimony, then why would I allow you to present any information to the jury?
Exactly.
Well,
you can't do that.
That's an interesting question, whether we even need to go that far. If we strike his testimony, the jury is to disregard it.
Well, you want to know what's even more interesting in my mind is how does this impact your punitive damage claim if the risk management department wasn't reporting up? But, I mean, that's another question, but regardless.
That one.
I don't know. I've had nothing else going on this weekend to think, so.
This is
Judge, you already made a ruling.
Have this
You already made a ruling. Why are we still talking?
It's spent the weekend, instead of me spending 100% of my time on the closing, dealing with this issue, because we were so worried about the impact it would make over on
I hear what you've said. I let you speak when it really was Mr. Whitney. So, Mr. Whitney, was there anything else you wanted to say before I let Mr. Hunter have an opportunity to comment on my game plan?
I don't believe so. Judge, you made the point I was going to make. If you're going to permit rebuttal, then an instruction would make that pointless.
Yeah. Motion to strike makes no sense.
Obviously, we've made the record. You know how we feel, but Your Honor's game plan, I would suggest that if you issue an instruction, there's nothing for them to rebut. So I think that the two things they're mutually exclusive.
I agree with that.
How can I strike his testimony, the witness's testimony at this point, when you've just made a full-throated argument as to why it doesn't matter and why the information you presented to the jury was legally correct? I mean,
that's a problem.
I feel like I'm in
it's like
between a rock and a hard place.
John Hopkins himself already said the testimony was legally correct. Right? Our witness said nothing wrong. Everything they said was true.
My point
we don't even know what the problem is.
I
also,
think
we want to strike it.
My point was and is going further with this is ultimately going to do more harm than good, and it's going to create more confusion and prejudice than otherwise would be the case to both.
Again, that's a you problem. That's great. Let's do 403. It's substantially more prejudicial than probative because they're going to expose us as liars.
But to approach it that way. But I would just suggest to the court and to all concerned that if Your Honor feels between Scylla and Charybdis on this, that the simplest and most direct approach may be an instruction. And I'll just leave it at that.
Plaintiffs move the court for 5 minutes to discuss the matter with appellate counsel. This is a big deal, and the court presents a very cogent argument about which one and how.
You don't want to strike it. You want the rebuttal.
I'll give you the 5 minutes, and then I've got a jury on ice right this second, and I've got to do something with the jury. But unless I hear something fundamentally different when you come back after having discussions with your various appellate counsels, it seems like the options that exist at this moment are, one, me striking the testimony of witness Mr. Anderson with some type of instruction to the jury that they're to disregard it, and then no rebuttal on this issue. Or two, you get some ability to present rebuttal today.
You want the rebuttal.
Hopefully, maybe right after lunch.
Yeah.
And
don't
then
screw
we
this
will
up. I'm
do
pretty sure you
closing
want the
arguments tomorrow morning. I'll try to instruct the jury this afternoon so that we can do closings in the morning, and then they can start deliberating at lunchtime. So, or maybe a little bit after lunch. So, that seems to me to be the two paths that I can walk at this moment without. I think those are probably the two best options I've got.
I agree.
In the situation we find ourselves.
I agree. Those are the two options you have. I agree with the judge.
Take 5 minutes, and I'll be back. Let the jury know it's still going to be a few more minutes before I can get to them. Thank you.
All rise. Closing recess.
So Maya's counsel is a half step away from talking themselves out of a win. So they're about to snatch defeat from the jaws of victory is basically what's going on. Because they themselves said, okay, how about a motion strike? First of all, so even Maya's counsel said, oh, well, motion to strike? And the judge is like, you don't want to do that. Right? You don't want to do that. So the judge is like, and the defense counsel points out quite correctly, Johns Hopkins is absolutely correct on this point, right? If we strike the testimony, there's nothing to rebut, right? Because that's correct. Because we do presume, as a matter of law, that the jury will follow the judge's instructions. So as a matter of law, if we tell the jury, hey, disregard all that testimony, they will, because juries obey the law, right? This is what the premise we're going with. So that means the testimony legally never happened, which means there's nothing to rebut, because legally it never happened. So option number one is I can strike the testimony. I can give the motion to disregard, which means legally it never happened, which means legally the jury doesn't consider it because they'll follow the instructions of this court. So the bell is unrung. Or option number two, I can leave in the testimony and you get an opportunity to rebut at a high level. And I understand the court's instruction. It wasn't that complicated, right? What the judge is saying is he doesn't want this to turn into a super duper like mini trial on like every little thing. He doesn't want this to turn into a huge thing. He doesn't want this to spiral out of control. He wants to, which is fine, which is perfectly reasonable, right? Let's keep our eye somewhat focused on the ball, right? Which are the causes of action here, right? This testimony that we're going to bring in is to rebut that all was well at Johns Hopkins, right? So that's what we're trying to do, right? We're just trying to rebut the all is well testimony. What the judge said earlier is, I don't want this to turn into a, detailed deep dive into, every little thing at Johns Hopkins, where suddenly now we're trying to adjudicate basically, well, was this heart procedure on some other person at some other time? Was a heart procedure on Miss Smith that occurred, on February 2014, where, a stent was inserted improperly? Let's have a whole trial about, that med-mal case, basically. It's like, I don't want to turn this into, 100 different med-mal cases, where I'm trying to adjudicate whether every single thing is or is not a med-mal. It's like, because we got to keep our eye focused on the ball. So what the judge said, and I think it's quite appropriate, it's like, look, I want to give your guy some opportunity to look at this stuff. I want to put him on the stand at 1 o'clock, and I want him to be done so that we can get, to closing argument today, which is pretty ambitious, but that's the plan, right? So the idea, at least in principle, is that your expert's going to be on the stand for something like 3 hours between direct and cross, during which time he will have an opportunity to highlight this stuff in a broad way, which is perfectly fine. It's just perfectly fine, and I appreciate, right? We're just going to talk about, and we're not going to get into the weeds of every particular thing. Well, maybe this wasn't med-mal. Maybe that stent was supposed to be there, blah, 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 right? So I'm like, okay, great. So I understand this. And this makes perfect logical sense. So it's like, okay, you have a whole bunch of boxes sitting here. It's 9:30 in the morning right now, right? So your witness gets on the stand at 1:30. So they've got 4 hours. This is rough, but this is what we want to do, right? You got 4 hours to go through a couple boxes, pick out a couple choice documents that show the issue, talk to the jury about the couple choice documents that, show the issue. They get some cross. We get our closing arguments. I give jury instructions tomorrow, and everyone's happy. It's like ish. Everyone's happy-ish. Or at least I've made a ruling. It's like I've made a ruling. And this is a criticism I'm going to make to the judge. It's like the judge made the ruling, and then he kept letting people talk. And I'm like, why? It's like, I've made the ruling. What did I stutter? It's like, no. So this is what I'm going to do, which I think is a perfectly reasonable thing to do. Again, the standard from an appellate posture is abuse of discretion. Judges get a lot of latitude on what witnesses testify, if they testify at all, what they testify about, what evidence is brought in. They get discretion as to evidence that's relevant. Then there's always 403, substantially more prejudicial, or it's off point, or whatever. It's like, nope, that expert can't testify. No, they can't testify as that. That evidence isn't coming in. This is some bullshit, right? So they get a lot of latitude. They get a lot of latitude because trials are complicated, and you got to figure out what the issues are and what's not. And so from an appellate posture, the judge can do a whole shit ton of things, and they be okay. And often, as I pointed out in an earlier stream, the judge can sometimes do something and literally do exactly the opposite of that, and they're both legally tenable. That isn't always true, but it's often true, because often, although not always, a judge can do something and also do literally the exact opposite, and they're both okay, because it's an issue of discretion. It's an issue of discretion. And the standard is abuse of discretion, basically being, did the judge screw this up so hard, no reasonable judge could have possibly done this. right? And that's a lot. It's a lot. So this works for me. The judge could have probably done anything. The judge could have, stricken the testimony. The judge could have opened up the floodgates to some degree, although I think there is definitely an upper bound out there, right? If this turns into even one additional mini trial, let alone 10 or 100, if we're going through, Johns Hopkins' many sins. If we suddenly turn this into a mini trial about whether or not some heart patient somewhere had a stent put in wrong, I'm just making this up for the purposes of illustration, obviously. But if we just turn this into some mini trial somewhere and we get off focus, then the jury doesn't know what we're doing. Because what are we talking about? Are we talking about Maya, or are we talking about this heart stent thing? What's the connection? So there definitely is an upper bound that way, but the judge's order made perfect sense to me. It's like, hey, you got a couple boxes, give your expert 4 hours, pick a couple choice documents, have them testify about the choice documents, say the word systemic failures or systemic whatever or culture or whatever it is you're going to say for a while, do a little cross, we do a little closing argument, jury gets the case tomorrow, hey, we're all moving on with our lives. So that's basically all the thing that's happening on that. Yeah. So if I think you want the rebuttal, because you want to expose them as liars, and the judge's order gives you enough latitude to do that. It's workable. It's not like ideal. It's tough. It's not great. I mean, hey, let's give our expert a couple boxes of documents, and let's give them 4 hours, and then let's ask questions about those. I mean, it's like, it's not great. It's not fun, but it's doable. It's doable. It can be done. And so I think you'd be insane to say, hey, let's strike the testimony. Let's unring that bell. I think the correct answer has got to be, yeah, let's give it a shot. Let's give it a shot. Let's get our expert on the stand. Let's pick a couple choice documents that say systemic failure, systemic culture, blah, 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 Johns Hopkins sucks balls. Ask some questions about that and call it a day. So I think the motion to strike is a really stupid idea. It's a really stupid idea. In my humble opinion, I think the motion to strike is a dumb idea. And I don't know why Maya Kowalski's lawyer said, yeah, motion to strike, because they did at one point. It's like, well, motion to strike. And why Johns Hopkins didn't leap on that like the leaping on the last grenade is beyond me. Because they even kind of mealy-mouthed it, a little bit. The moment they said motion to strike, it's like, well, counsel just said motion to strike. We love motion to strike. How about motion to strike? That sounds great, Your Honor. Motion to strike. Let's strike. They said it. They said it. Like, why they didn't leap on that like it was a grenade in war or something, I don't know. But so both counsels have made some errors this morning as well. So, yeah. That's sort of what's happening. And good morning, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others, as we're seeing Johns Hopkins' misfortune displayed before our very eyes. I'm your host on Civil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I'm happy to be sharing this with you as we watch Johns Hopkins die slowly in front of us. Yeah. Yeah. Philip says, if you gave me a bunch of boxes and told me to go through them in 4 hours, I'd be less than happy. I understand. As I mentioned, it is not ideal. It is very not ideal. Yeah, go through a couple boxes. Find the. You're doing doc review like under the gun. It is not fun. But like the your incentives and motive to succeed is very high. So yeah, it's not fun. But yeah, get a couple lawyers in a room and start tearing apart boxes rapidly. Is there a video summary of this trial that could be recommended? Why, yes, there is, as a matter of fact. If you go on my channel, there's a great video taking care of Maya from last week, I believe, at this point, where I give a summary of this from the medical perspective. So I would recommend checking out that video so you can learn a little bit about the journey of Maya Kowalski and some of the things she's been through from a medical perspective. Yeah. Why weren't plaintiffs already given the boxes? I don't know the answers to these questions. I don't know why we're doing discovery on literally the last day of the case, but this is where we're at.
Please be seated, everybody. Starting with the plaintiffs, what are our thoughts at this point?
Our thoughts, Your Honor, are if it's an either or, we would, between an instruction to the jury striking the stranger's testimony or putting in some limited evidence and rebuttal testimony of Joseph Corcoran, we would take the latter. We would like to proceed in rebuttal.
That's the right answer.
We would prefer, even then, a brief instruction, but if it's either or, that's our preference.
Yep, that's right. It is either or.
And
it's either or.
What's your view of
legally? It's either or.
Doing it, let's say, like at 1 o'clock today. Give your folks time to get prepared. Your expert, if they need to look at the other documents, and then doing closing arguments tomorrow. Because remember, I still have to deal with jury instruction issues.
I understand. We prefer. Dr. Corcoran was here on hot standby this morning for a reason. He has a doctor's appointment this afternoon. We would prefer to proceed immediately into that.
Okay. If you're ready to go now, counselor, now works for me. The judge was trying to be nice by giving you an extra 4 hours, but they're like, we're ready to go now. If you're ready to go, let's go. Let's do it. Chop, chop, chop.
And I've narrowed down the exhibits that we would put
Stop talking. All right, call him to stand. Let's go.
Let's say
move
the the defense.
Judge, we would, if that's our choice and
it's not
choice at that, we would.
It's not your choice.
That it is simpler and more straightforward to do an instruction.
No, it's not your choice. You misunderstood. It was plaintiff's choice.
Dr. Anderson's testimony regarding
it's plaintiff's harm. It's plaintiff's choice. You don't get lines in this play.
Hurriedly drafted.
I bet you'd prefer to strike. I bet you do.
The question that I would have, I don't know. We haven't discussed parameters of the rebuttal testimony proposed. And
shut up.
I would like to hear that, and I'd also like to hear whether or not we would be accorded Sir Rebuttal.
Sir Rebuttal. Oh, you want Sir Rebuttal?
Why would I give Sir Rebuttal when it was the defense that opened this door?
Damn straight.
I don't know what the rebuttal is going to be, Judge.
No, you can't have Sir Rebuttal. Absolutely not.
Well,
no. Shut up. Sit down. You lost.
Ultimately, like I said, I've reserved on the question of sanctions. I think the question of striking pleadings is probably not something that I ultimately would physically do, given the nature of this case.
What's a Sir Rebuttal? It just means Sir. It just means on top or
plaintiffs
extra.
An opportunity
or
to
means, what does it literally mean?
To cure the
means above.
The
literally means
present
above.
Evidence.
So you have the case,
in rebuttal
you have
to the evidence
response,
that
and then you have rebuttal.
Presented.
And they want another turn. They want another turn.
I'm willing to do that this
so you
morning.
You get the plaintiff's case, you get the defense's case, then the plaintiff offers rebuttal to the defense's case.
I do think Mr. Hunter
what
has
Sir
a
Rebuttal
point.
would be is we want a rebuttal to plaintiff's rebuttal. We want another
parameters. So
we want an additional phase.
If we do the following.
We want a fourth phase.
Over the next 30 minutes, we can discuss the parameters. We tell the jury to come back.
Absolutely not.
Or to stand down and be ready to go at 10:15 this morning. We'll do the rebuttal case. I'll send them to lunch. We can work on jury instructions, issues. Hopefully instruct the jury this afternoon on court instructions, and then closing arguments tomorrow morning. Does that
that the time is acceptable to plaintiffs. As far as sanction, we would ask the court to reserve on DVs.
They already said that they're reserving.
Yeah.
Shut up.
Still on reserve, I'm sorry.
On directed verdicts, reserve on directed verdicts, okay. Mr. Hunter, anything further on
No.
that game plan?
No. Okay. And if the next
What I'm
words
gonna
out of
do
the
is I'm
judge's
gonna bring
mouth
the
are,
jury in.
yeah,
I'm gonna tell them we're gonna take a recess until 10:15, so maybe they can go outside and stretch their legs or whatever, so they're not sitting cramped in their room. So let's bring them in.
yeah. I want an additional phase. I want a fourth phase. You know, the plaintiff gets a turn to call witnesses, then the defense gets a turn to call witnesses, then the plaintiff gets another turn. The defense is like, can we have a fourth turn? No, absolutely you cannot have an additional turn. And the judge is right. This is a you problem. Why would I give you sir rebuttal when you're the ones that opened the door in the first place? Because we don't know what they're going to say on rebuttal. Yeah, I bet you don't. I don't care. Go away.
Okay, please be seated, everybody. Hey, members of the jury, I want to confirm while you're away over the weekend, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
And no one approached you about this case. Is that correct?
Correct.
Now, have any of you seen any media accounts about this case?
No.
Including any media accounts over the weekend or since you last were with us? Okay. Don't pull out everything right this second. I'm going to need a few more minutes to get us to the position where we can have the rest of our case presented to you. So it's going to take me, probably another 45 minutes or so. I didn't want you to have to sit there in that room for another 45 minutes. So I'm going to let you kind of go out, maybe go outside and walk around, whatever you all want to do. I am going to ask that you be back at 10:15, and so we can proceed. It's all on me. I'm the one that is slow and not getting us to where you want to be this morning, but it's all on me. So don't blame any of the lawyers. It's all on me.
It's a little on you. That is fair.
Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And I'll see you back in about 45 minutes.
All rise. Jurors exiting.
I suppose the juror issue's been resolved, I guess, by implication. I guess the answer was mostly no, which is fine by me. I wouldn't have any argument about it. I'd rule summarily. Yeah, on your motion to disqualify, it's denied, would be basically all I'd say.
The jury's out of our presence. Everyone, please be seated. Now let's talk about parameters.
All right.
Mr. Whitney, do you have an outline, a plan, a thought process on this issue?
Your Honor, we have 7 exhibits that we would intend to use.
Okay, and what numbers are they? So we're
That works.
2811, 2815, 2817, 2818, 2819, 2821, and 2822. And so the rebuttal would consist of me asking some contextual questions of Dr. Corcoran and then proceeding to further contextualize that by showing him these series of exhibits. When we talk about parameters, I heard the court earlier that this is not going to be a deep dive into the Heart Institute, and I'm willing to abide by that. I think the challenge that the court faces is I would expect that the cross-examination of Dr. Corcoran would center around this was all the Heart Institute, wasn't it? So I don't know how we deal with that issue.
Well, I mean, I think, well,
Judge, looking quickly at the exhibits they've listed, the Agency for Healthcare Administration complaint investigation, 2811, I don't, I'm at a loss to understand the relevancy of that to what Mr. Anderson said or how it relates to this. I should say witness Anderson. The emails from the 2817 was actually a forwarding of an email to me. It was an email that was sent to Ms. Green in real time that she then forwarded to me, and that was what was produced to the plaintiff. In other words, her email forwarded to me. So I'd like for counsel to come off of that.
Just forwarded. Just forwarded.
I mean, redacting out your name or reference to you.
Right.
I mean, I think that's what we've been doing with others that went to you.
Right, and then otherwise, that's an after the fact matter that we would respectfully object to.
Well, I'm going to need to see these documents if you're objecting to them. So tell me which ones you're objecting to, so I can make a ruling on them.
We object to 2811.
Let's pull that up, please.
Your Honor, 2811 is what I referenced in my response to Mr. Hunter's argument. This is an ACCA deficiency report dated February 23rd, 2017, approximately 1 month after Maya was discharged. The two specific citations, well, first of all, specifically a risk management survey. If you look at the third paragraph in the left column. And the two specific deficiencies are patient rights and care, coordination of care. And the other is on page 8 of 14 at 2811-008. It's patient rights and care, patient and family education, both relevant issues.
Well, is there anything in this document that references out the Heart Institute or did you say 13 or 18 deaths that occurred in the Heart Institute?
Nothing in this document deals with the Heart Institute.
Okay, so can you go to just the next page just quickly and then...
It's been redacted for patient identification information.
Next page, please.
Yeah, I can't read any of this. I don't know if any of you guys can, but I can't read any of this. So
Next page.
I don't know what they're talking about.
Judge, while you're looking at that, I'd like to call attention to the fact that it concerns itself with discharge arrangements and discharge planning.
Next page. Next page. Next. Next. Now, what on page 8 did you want to highlight?
I was just pointing the court to, if you see the far left column, at the bottom of the page is H023, and then it cites the specific Florida Administrative Code section for patient rights and care, patient family education. So there's two kind of overarching administrative code deficiencies in this document.
And this is a February 2017 document?
Yes, Your Honor.
Okay, next page. Next page. Next page. Next. 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 Okay. Besides relevance, Mr. Hunter, any other objections?
No, sir.
Court's going to overrule the relevance objection and receive into evidence 2811. What's the next document? That Mr. Hunter, that you have an objection to.
0 for 1, Johns Hopkins. No, that document's coming in.
2817, Your Honor.
Okay, so there's no objection to 2815, is that correct?
No, sir, that's the immediate jeopardy notice.
Okay, so the court will receive into evidence 2815. Is there anything that needs to be redacted on 2815? Or has it already been appropriately redacted?
2815, Your Honor, is the CMS letter that was sent to the hospital on January 31st, 2019. Mr. Anderson, gave you a copy last Wednesday. It's a matter of public record. I don't think anything needs to be redacted.
I don't know of anything that needs redaction on that, Judge. It is public record, and that is the IJ notice.
So we're at 2817. This is the forwarding to Mr. Hunter. So can we pull that up?
So we would redact the top block, everything above halfway down the page where it begins with Angela Green to Susan Franklin.
So we can cover up the Howard Hunter all the way through external email, exercise caution?
Yes, Your Honor. That was just forwarded to him on Friday evening during the deposition.
Is there anything besides removing your reference in your name, Mr. Hunter? Is there anything else?
The only, it's just relevance, Judge. I mean, these are talking points for a board presentation, and I don't see the relevance of them.
Can I see the next page, please?
So if I could orient the court.
Sure.
The email you see there, Kim, addressed to Kim, CMS 2567 is the form number for a CMS statement of deficiencies, or what we're calling the immediate jeopardy notice. This is internal emails between the patient safety risk management teams at the hospital. If we go to the next page, they're developing talking points. Kevin referenced here is Kevin Sowers. This is the interim CEO brought in, and it discusses in a high level what they need to address based on different citations that were noted in that January 31st letter. Can we go to the next page, please? Next page. Here governing body, this is an organizational level issue. And so it talks about the leadership transition, the resignations of 8 leaders. It talks about restructuring risk management. And it talks about the very bottom bullet point there is the massive education campaign, which talks to the fear of retribution present in the hospital during the time. Ms. Green testified that of these bullet points here, 5 of them were related to risk management issues. I'll stop there.
And is there anything on this document specifically referencing the Heart Institute or those 13 or 18 patient deaths?
There may be. In fact, maybe the previous section there, I see at the top it says something about institute. Can you go back up a page for me?
Be right back, guys.
Yeah, I mean, so number 1 here, halfway down the page, says halted all congenital open heart surgeries, meeting with families of children. This is the 13 deaths they discovered. Some of these are more general. Suppose we could print this out and suggest some revisions to eliminate Heart Institute issues.
This to me, the rebuttal is not going to go into the question of the Heart Institute and those specific patients' death. I don't want to talk about patient deaths.
Okay, understood.
In rebuttal.
Understood.
So that type of information has got to be redacted. So anything else about this document, Mr. Hunter? I know we're going to take out your name from it.
Right. The only other thing I would point out to the court is that beyond the relevance of it, this is This is essentially a recitation of subsequent remedial changes, and we objected on that basis.
Mr. Whitney.
I see the court's brain working, mine as well.
Very slowly.
Me too. Can you go to back to the advance the page to risk management again, please? Page number 5 or 6, I'm not sure. There we go.
Judge, my point is the entire document is basically talking points on a report to the board about a response to these entire matters. So it's, I mean, that's what this is.
So I suppose it's baked in here that these are measures that they are taking in response to the immediate jeopardy notice. However, they're also acknowledgments of the conditions that existed. For example, without fear of retribution is not a remedial measure. It's an acknowledgement of the culture of the hospital.
I agree with Mr. Whitney that this identifies the problems that existed and it goes to rebut the evidence that the defense presented to the jury. So, anything else, Mr. Hunter? Okay, so we're going to remove the Mr. Hunter information. We're going to remove the Heart Institute information. Otherwise, the court will receive, as redacted, 2817. Do I need to make that an A?
Probably.
Okay, so let's call it 2817A, and I'll need the plaintiffs to print out and give the clerk the redacted version.
We could have a copy just to compare, because I think I saw another Hart reference earlier in the document.
That, please do, yes.
We will work with the council on that. The next is 2818. I don't know if there's an objection.
Can you pull it up? Obviously, we need to take out Mr. Hunter's name there at the top.
Understood.
And was this sent to Mr. Hunter?
On Friday. Wait.
No, but did any of these emails?
This one, he was just, Mr. Hunter was the one printing out these emails on Friday evening.
Right, I get it. But within this email chain was, in 2019, was he on?
I have not seen his name. You can correct me if I'm wrong.
No, sir.
Okay. So we're taking his name off. Anything else in this document?
Is this the only page of it?
Next page. What are we using this document for, Mr. Whitney?
One moment. We're using this document because, Your Honor, this is attaching the draft corrective action plan, which, if you advance to page... All right. You advance to page 7. So what you have here, Your Honor, in the left column, the large left column, you have the statement of deficiencies from CMS, and in the right column, you have the negotiation between CMS and Johns Hopkins Children's Hospital as to what will need to be done to correct the issues and acknowledgement of the issues throughout. And this is what I was referencing in my argument earlier with respect to certain pages that speak to 8 key executives leaving and risk management not being properly integrated, etc. So I would reference certain pages here.
Well, is there, again, going back to the Heart Institute / deaths, anything like that will have to come out if this document comes in?
I understand it's a long document.
How many pages is this?
121 pages. And that's the survey and corrective action. It's 128 if you include the email.
The way these things are set up, Your Honor, is you're sent this form 2567, whatever it is, and then the suggested plan to address it, the subsequent changes to address it, are put in a column that relates or correlates to the alleged deficiencies. So that's why the length is because of the format, if you will. But we point out to the court again that this is the statement of deficiencies, and then it's a plan that is outlined in the right-hand column to address alleged deficiencies that are the subject of this witness's testimony. So this is a document that outlines proposed subsequent remedial changes.
Well, let me just ask this. Is this a document that you actually need, or is it duplicative of the talking points? I mean, isn't your expert going to talk about it, and then does this document physically need to come into evidence if there's a lot of Hart Institute related things that would have to be redacted?
I don't think it's duplicative, Your Honor. I think the jury, given the impression they were given, needs to understand what the actual situation with the federal regulators was, and this is the best document to do that. And I can simplify this process by A309 is the, if you look back, it references failures at the governing body level. So those discussions begin at page 57 of this document and continue through page 79. And we could relatively quickly review those 22 pages plus the email to redact out Hart Institute issues.
And then just redact the other pages that
And
are...
just leave out the other pages.
Judge, it is a chronicle of subsequent remedial changes. B, it is going considerably beyond the testimony that counsel is intending to rebut. This is going deep into details of multiple matters that have nothing to do with the very simple, straightforward statement that we're rebutting. And I'm looking at page, what is it? This is page 57. There's a discussion of a plethora of details of Hart Institute issues and indications, starting with ventricular shunts and hand hygiene and working its way down.
I suspect this is actually page 51 of the report, and it just happens because of the email is identified as page 57.
Oh,
so
yes, I'm sorry. Yeah, we need to move forward 6 pages. Next, there. That begins, you see in the middle column, A309. That's the governing body failure.
Can you make that a little larger, please?
Keep going, please.
Not wall larger. Thank you.
Well, again, this goes into, the top of it goes into the heart and diaphragmatic hernia program. Yeah, I think Your Honor may have hit the nail on the head as far as this thing being duplicative and unnecessarily detailed if you've got the other exhibits in.
This is what we're going to do with this document. The 20 or so pages that are, is it code A309 having to do, is that the one with the risk management component?
Yes, Your Honor.
Fine, okay. So you're going to just either redact out everything else or not include the pages. I don't care, but you know, it might seem better to leave the pages in and just redact it because the jury has been very curious about documents, but I don't care. And then for those 20 or so pages, we need to redact out references to the Heart Institute or those specific patient deaths.
By 10:15.
The art of the possible at this time. Miss Lawrence is working in overtime right now.
Understood.
What's the next? But once we do that, I will overrule the relevance objection and subsequent remedial measure.
Yeah, the
objection
general
in
consensus
minutes.
is the hospital is
And
at
that,
least
I'm sorry,
partially
Art,
at
just
fault.
clarification.
How much is still very much in
Setting it.
dispute. Not for a list of reasons that delete the law that they're trying to do here with respect to
Whatever the
Maya's
first
mother's
page
death.
is with respect to
is
when it starts
novel.
talking about the risk management
So
department issues.
the hospital definitely made mistakes.
What's next? And that probably needs to be an A.
But
Understood.
how much is a little bit in dispute, I think.
2819 is next. This is internal. We will redact the top block with Howard Hunter receiving it on Friday evening. And then what follows is the management presentation. Next, please. There, we would just need this slide
Yeah,
here.
the steps they
Talks
took
about
before they had a court
governance
order are
and culture.
obviously legally failures for
And
the
then,
hospital. So everything they did
fifth page,
before they had a court order in hand
1005 talks about
is
failure to document adverse events, including
the
disclosing
damages
of
there,
errors.
though, are relatively minor in the grand scheme, though. You're not talking about huge
That's what
numbers
we'd
for
ask
that.
for from that document.
And then you're planning on redacting
Not
the
like
balance.
$200 million
We can do that
numbers
now.
that you're seeking. The
Same
big
objection,
numbers are for Maya's
Same
mother's
ruling,
death,
as
Maya's
redacted, I
mother's
will
death, but
Allow
as I say,
that
that's legally
2819 into
problematic at
evidence.
best.
2821, please.
Is this going to be just the letter or the letter and the attachments?
Right. The attachment, again, is the statement of deficiencies, so we can forego that. However, the letter, addresses, beginning on page 3, risk management issues. There would need to be some redactions here, because the first one is the deaths from the Heart Institute.
Risk management, review of cardiac deaths,
Same
cardiac
objection,
cases submitted
Okay,
to
so
surgery. This is high
obviously
level.
that B1A needs to be redacted out. And then the previous couple of pages that talked about the Heart Institute needs to come out.
Yes.
Is there anything past this
And then,
in the letter, not the attachment, but in the letter itself?
yes, Your Honor, if you go to section D, we get to governance leadership, and it discusses the ethics committee, which has been subject of some testimony here.
Anything else, Mr. Hunter?
Same objections, Judge. This is a chronicle of remedial change.
I overrule the subsequent remedial measure issue. This goes to the actual problems and goes to rebut the evidence that the defense adduced in its case in chief. So as redacted, the court will receive 2821.
There's
So
one
they're
more
striking
page I wanna
mention
strip
of
out on that,
deaths.
which is page 6.
Okay, fair enough.
And there, number 4 picks up a governing body. And again, these are related to governing body issues. And then closing with 7, which would be the signature page.
Right, but number 3, let me see what number 3 was. Infection control, that's out, right?
All that above that would
Yeah.
be, above 4 would be out.
And we would add the objection, Judge, is cumulative with the others.
Overruled that. Anything else on this document, Mr. Whitney?
No, Your Honor.
Okay, as redacted, the court will receive it.
All right, and that takes us to 2822.
Plaintiff's counsel understood the assignment though, right? Because they started with like, we want to bring in 7 documents, which is inherently just a very reasonable number.
It's an internal email involving
so they didn't overshoot the meeting.
The top portion here with Mr. Hunter's name. And what's really critical is beginning at page 4. And we only need the top box on page 4, which again goes to governing body issues and talks about, at the bottom of that box, speaking up for safety and long-term justice.
Myers lawyers cost. I'm sure they're doing it on the
Redact out
contingency.
that second bullet, the
40%.
surgery programs,
Yes, Your Honor.
If I imagine.
and then everything else is being redacted.
And we'll redact the balance beginning
Check
at
1, 2.
1B and those bottom 2 boxes.
Check 1, 2.
Anything
Hard to hear
in
me.
addition
Check
to
1,
this
2.
document.
Check 1, 2.
There are some objections.
Okay, as redacted, the court will receive 2822.
The only thing we need
Check
to do
1,
is,
2, 1, 2.
is admit the mortality tables, which are the first exhibit
Turn
listed.
down the court audio a little to
provided
balance it out a little bit
counsel.
better.
And so, for the record, those are 2060-002, and then continuing at 47 to 50.
Any objection from?
No.
Court receives 2060 pages 2, and then pages 47 through 50. Is that, did I read that properly?
I could probably turn up the output gain.
Anything else as far as exhibits?
One second.
Shit, let me turn up the gain a little bit on my mic. Turn it up to
So we
12.
have a couple of exhibit issues, but not related to their rebuttal.
Check 1, 2, 1,
Is
2.
it something that?
Hello, everyone.
we can
Welcome to
all
Uncivil
agree
Law.
just
Okay,
to-
it's a little better.
After we send the jury home today?
More
it
gain is
possible,
good.
Or do we have
Yeah,
to?
there's just, the only, well, we need to, after the jury goes home, you're saying, Judge?
Yeah.
Yeah, we just want to, we're asking to admit an exhibit we forgot. It has nothing to do with these issues.
So long as we can do it after I send the jury home?
Yes, I don't see why we could not.
We are done.
Okay. Let's shift gears for a moment. We have the question of juror disqualification. Do you want, because we've got time issues with the expert, do we want to postpone that discussion until, a little bit later on today?
That's fine for the defense, Judge.
Yes, from my perspective.
Okay, and then
I would just dismiss it
before we
summarily,
take
but
our
apparently
lunch, we
they
need
want to do it on the record.
have a final discussion and nail down the jury instructions. So what I would propose is we do this testimony, and then I guess you're going to rest after you present your evidence.
Yes,
I'll send the jury to lunch, and then we'll work on jury instructions, deal with the DQ issue, and then take our lunch, and then come back, and the court will read the instructions so that first thing tomorrow morning you can do closing arguments. Does that game plan work for everybody?
Yes, sir.
It does, Judge. I just don't know when they're going to be able to get us the redacted documents.
Well, my hope, should I just give you 10 or 15 minutes right now to work on that, and then come back, let's say, at 10:20, and hopefully we're large way there?
We'll be most of the way through it, and if there's one that we can't get redacted in that time, we won't present it at this time. We'll just move it into evidence once that gets worked out.
So should I come back at 10:20 or 10:30?
10:30 would be appreciated.
Does that give your... Okay. He's got enough time, so I will be back at 10:30. Let the jury know that we'll be starting just about 10:30.
All rise. Closing recess.
All right, so we're in pause. So I guess we're going to still have a motion on the jury disqualification, I guess, but, whatever. So, defense is whining. Hold on a second. Hello? No, I'm fine. Thanks. Dad says hi. So this is I like the way the judge is ruling. My only criticism here is I wish the judge was a little bit more definitive about it. He's a little wishy-washy. He, just he lets people keep talking and he doesn't make a decision as fast as I want. He doesn't stick to the decision. Be like, this is the decision. So, yeah. But other than that, it's fine. So, yeah. So for the 485 of you who are here, thank you for joining me, by the way. I appreciate that you're here as we're watching this thing unfold. So Johns Hopkins is going to have a little bit of rebuttal testimony. Judge went and pre-approved all the evidence that's going to be brought into this thing, which fine. So pre-approved what evidence is going to be brought in so that everyone understands what the rules of this thing are to prevent it from going out of control. Cool. I appreciate what the judge is trying to do. I appreciate the way the judge is trying to do it. The judge's rulings are defensible, which is all that you really want, really. The judge could do other things too, and those would also be defensible. You get a lot of latitude, I don't think the juror is going to be dismissed. I thought the motion to dismiss the juror was laughable. I'm surprised the judge is having any hearing on it, to be honest. I would have dismissed it summarily. I would have just simply said the motion is denied. But, the judge wants to have a hearing on it, I guess. Defense seems super shady. Well, it isn't really the defense per se, as so much as Johns Hopkins, but perhaps that's what you mean. Johns Hopkins did some shady shit. And it's being held accountable for some shady shit that they did. And, yeah. Does allowing argument affect the issue of judicial discretion at all? Somewhat, yeah. It makes the record clearer for the reasons, I guess, but in the absence of that, the Court of Appeals will invent reasons. So, in the absence of the trial court providing a rationale, the Court of Appeals will just provide its own rationale. So any reason they can find to make it work. So, Marvin CZ gives 500 Czech. CZ, no, that's Swiss. Swiss krona. 500 Swiss krona. Thank you very much for saying, thank you for your perspective. It's very helpful. Thank you very much. It's just over $20. Hey, $20 is $20, man. Check? Damn it. Try to be all smart and I get walloped. Well, Czechoslovakia and Switzerland are near each other. It's like the same country, right? Yeah. That's just all of Europe. Yeah. CH is Swiss, that's right. There's no Czechoslovakia. The Czech Republic. Yeah. All right. So I'm still stuck in the 80s. Damn it. That's two mistakes Uncivil's made in trying to get countries right. Damn it. I would love to visit someday. I'd love to visit someday. It's definitely a part of the world I'd be interested in checking out. The case with the social worker, I believe, was settled. So I believe they came to some kind of settlement. Lawyer doesn't need geography? Well, I'd like to not perpetuate the stereotype of the American who doesn't know other countries in the world and that they exist, and vaguely at least where they are. I'm not sure I could necessarily point to the Czech Republic on a blank map, although I know vaguely where it is. At least I point to the right part of the subcontinent, so that's not too bad. Pointing to the right part of the subcontinent isn't too bad for an American, right? That's all right. I'm not surprised that Johns Hopkins is getting whacked around in all this. They made some very bad mistakes. And their biggest mistakes, at least to my mind, are in the stuff before they have the court order. Right? When Maya's refusing particular treatments, when her parents are refusing particular treatments, it's like, you can't just do those things. Consent to treat is consent for any particular treatment. I don't think so. I really like that one where it was Jimmy Kimmel, where they took a blank map of the world on the streets and asked people point to any country. So it had all the outlines of all the countries, right? But none of them are labeled. And they just said, name a country, literally any country. And people couldn't do it. And it was sad. Except for one 8-year-old or 10-year-old or 12-year-old, however old he was, and basically pointed to 15 different countries correctly. But these college-educated people couldn't name any country on the map. Where's the United States? No clue. Can't find it on the map. Literally name any country. Can you point to it on the map? Literally name any country. No, they can't. Do I think it was a mistake, the hospital trying to be 100% in the right? Interesting question on a strategic decision. I don't know. I'd have to really think about it in the context of everything. A tactical concession can sometimes go a long way. I believe a lot of the videos look at how dumb as we ask people on the street are cherry picking their data. I'm sure that's true. I'm not sure how much that necessarily encourages me. These people, I'm a college grad. I can't find any country in the entire world, and I can't find any country on a map. None of the Brazil ones, or none of the big ones. You can't find China, or Australia, or US, or Canada, or Russia, or Brazil. The big ones. That's a good place to start. What's the most an attorney's been sanctioned? I'm not sure what the record is for the most for an attorney being sanctioned. When Trump's lawyers were sanctioned for $1 million, it was a pretty notable amount. What's worse is they can't name a member of Congress, any member of Congress. Yeah. I mean, there are a lot of them. Sealand is? Yeah, Sealand. If you can find Sealand on a map, I'll be impressed. Can you name any members of the U.S. Supreme Court? But they can name all the Kardashians, you know? What will happen to defense for not following orders? That's been held in reserve. Probably nothing. Just being frustrated. Is Sealand in the English Channel? I was under the vague impression that it was off somewhere in the north, like off to the northwest. You know, somewhere. But is it? No, I don't think it's in the. I don't think it's in the English Channel. I think it's somewhere. I can't find it on a map. I thought it was somewhere like vaguely off the coast of Scotland somewhere. But yeah. Yeah, U.S., Canada, Italy, Australia are easy. Brazil's the really big one in South America. Really big. South Africa. I'll give you a clue. It's in the south of Africa. Yeah, Africa's hard. Let's see. Egypt, Morocco, Chad, it's a big one in the middle with the lake. South Africa, Somalia. What else can I name in Africa by location? Let me think. Egypt. Yeah. Qatar. Well, yeah. Not so good on the African countries. Ethiopia. Probably could find that on a map. Morocco's pretty easy. Morocco was the first country to recognize the United States as an independent nation. There's a little factoid from world history. Chile is not in Africa, I'm pretty sure. Chile is copying Texas's flag. Ivory Coast, yeah, I'm not sure where the Ivory Coast is. At least it's probably on the coast. So I got that going for me. Madagascar. Yeah, Madagascar, yeah. Is the Morocco thing the reason why there was some kind of early treaty people were allowed to say the U.S. was not founded as a Christian nation? Yes, I think that was Morocco. What was the name of that treaty? But yeah, there was an early treaty in the United States, like 1787 or something, which said in part, as part of the treaty, the United States is not in any sense a Christian nation. So yes, you're correct. Was that Morocco, that treaty? It might have been. But yes, you're correct. Yeah. The United States is not in any sense founded as a Christian nation. Yeah. Nice recall. Nice recall. What's going on in court? Nothing right now. The court's on a break. We're just chilling as we're waiting. And talking about world history and treaties and where countries in Africa are located. Can I explain how hung jury works for criminal trials? Why is it not acquittal if a few reasonable jurors didn't find the case as convincing? Just because it's the rule. I don't know if there's really a satisfying answer to it either way. We just require the jury to be unanimous either way. So there's no real satisfying, I mean, from a historical perspective why that's true, I don't know, I'd have to dig into English common law to find out why that's true. But yeah, I don't know the historical origins on that particular thing about the unanimity requirement for acquittals. The court site has a 327-page motion for sanctions just posted. Who writes that much, man? 327 pages? Who writes that much? There should be a law against that. East Carolina grad Keaton Michael's first game, 184 yards and 1 touchdown. Okay. No, yeah, you need unanimous either way. You need unanimous either way. Unanimous guilty or unanimous not guilty, either way. So yeah, if you don't have that's what a hung jury is when you don't have unanimous. The judge ruled that some evidence of Johns Hopkins systemic issues can come in. There was a little conference just now about exactly what that evidence is. They talked about 7 documents that are coming in, which will be partially redacted. I believe they're redacting stuff dealing with actual deaths that occurred. But they're allowing the expert to come in and talk a little bit about some of the systemic issues at Johns Hopkins. And they just had a discussion about exactly what that evidence is. And so they're in the process now of redacting out that stuff so that they have exhibits to present their expert to talk about that. So that's where we're sitting. Thank you, Nikki, for saying you watched my 10-minute summary and learned all you needed. I did spend quite a bit of time and money and energy on that, so I'm glad you found it valuable. I really tried to bring you guys... It's a complicated summary, a complicated story, and I wanted to focus on specifically Maya's medical journey and some of the key players, so I chose, to present one portion of the story, but I'm glad you found it valuable. So I spent quite a bit of time and money putting together that video, so I'm glad you liked it. Thank you. Thank you for the compliment. That's very nice. And on a different note, we have raised, what, $107,000 last I look for a children's hospital through Ian's fundraiser. So that was really cool. We raised money for the children, for a children's hospital in Canada. $107,000 last I looked is probably a little higher than that now. But it is awesome that we were able to raise so much money for charity. People seem to really like QVC, Uncivil. People seem to really like that. So I was glad I was able to offer some value in talking up these lovely products. $107,273. $107,303. Yep, so yep, there you go. Yep. The rock was pretty good. We sold a rock for $450, which is pretty hilarious, not gonna lie. We also sold Moo Cow Friend, which needs to be shipped pretty soon, which I believe went for $365. This bobble-headed moo cow has been spoken for, so you can't bid on it. But as you can see, it's a bobble-headed moo cow. It bobbles. See? It bobbles. And it has a little springy tail. So this went for $365. So And a lot of the pens that Rob has made went for quite high money. Rob is a great crafter in his own right and sold some wonderful pens for some high value. The outro pen, the pen that is featured in his outro, I think went for $4,700. So
Hey, please be seated, everyone. Where's Mr. Whitney and Miss Lawrence? There's Mr. Whitney. How are we coming on those exhibits?
Well, Judge, I'm finishing reviewing 2817, and there were multiple things that Mr. Whitney agreed had to come out that hadn't been taken out yet.
Bit of a mess right now still, to be honest.
Well, what's the game plan?
We take up something. Should we take up something else?
I'm feeling very
Well,
relaxed.
I thought the issue was
I'm visiting my
your
parents,
expert
as you can
had-
tell from
couldn't
this
be here
remote
this
setup.
afternoon.
Don't have the standard camera, don't have the standard mic.
Well, they're trying to get all the exhibits together.
Visiting my parents and having a great time, by the way.
What we can do in that time, but
Well, I can't deal with anything else right now.
And my mom is cooking for me, and my mom is an outstanding cook. So,
how long it's going to take, Judge?
I only need 2 or 3 of them to do the rebuttal. I don't have my arms around right now what 2 or 3 are ready. We've got 4 people scrambling, working on it, printing in the hallway, giving it to Miss Crawls. We're doing our best.
last night my mom made some
Tomorrow's Tuesday.
sausage on top of pasta, and the sausage was really good. She did a really good job with the spice blend.
Our expert, one question.
It was really, really tasty.
We're just trying to figure out how late he can depart late this afternoon in case this needs to be shifted to maybe even take an early lunch. I'm just throwing out options here. And bring him back. After an early lunch at 12:30 or something. He's confirming that.
Dr. Cochran, what time do you need to leave?
Your Honor, I think I'd need to leave around 2 o'clock. I'm going to call the office and see if maybe I can be a little bit late. I have a procedures.
I don't really want to start later than that because
Start later than.
you're going to have questions, and then I'm sure Mr. Hunter's going to have questions.
Yes. And so if we
I don't know, somebody from the defense side.
Sure. If we started at 12:30, I would not have more than 45 minutes of questions. That gets us to 1:15. If they have the equal amount of cross-examination, that takes us to 2 o'clock. Just an option.
Let's go.
I mean, I'm reluctant to ask this question, but what if we call him, let's say, at 8 a.m. tomorrow morning, ask the jury to be here super early, and we do the rebuttal tomorrow morning, we then instruct the jury closing arguments, and then maybe even let them start deliberating. I mean, I don't know, they might have to start deliberating on Wednesday.
I'll just ask him the question if he's available tomorrow. I'm going to ask that question.
Judge, are you concerned if we start at 12:30 that we won't be?
I want to give this jury as much time as we possibly can to deliberate.
Right.
I would love for them to start deliberating tomorrow, as opposed to Wednesday.
Right. So, what's the court's reluctance, I guess, to start the witness at 12:30 so we can get all the exhibits situated, or 12?
My preference is to get him on and off today.
Right. Right.
Strong preference.
Right.
That being said, we are so far down this road, I don't want to do, because of rushing, I don't want to do something that is problematic.
Dr. Corcoran can leave here as late as 2:30. So if we start at 1 o'clock.
Got to be in my car, sir.
And he's not available tomorrow.
Get him on the stand now. Call him now.
Judge.
Do it. Work through lunch. The
If
jury will
we
live.
started at 12, will you be ready with your exhibits?
I can confidently say yes, we'll be ready by 12 o'clock.
I believe so, Your Honor.
I'm sorry?
I said I believe so, Your Honor.
Okay. But I also have to deal with the jury instruction issue, because I really want to try to instruct the jury this afternoon, unless you all say that's just, we're doing too much.
I think we would prefer that as well. Have them instructed this afternoon and get through as much as we can.
We would as well, Judge.
Now, let
How
me
hard
hear
is
from
it to
Mr.
mark up
Alford,
these
since
exhibits?
I don't think that disagreements and things that we have left on your instructions are that.
How hard is it to mark up these exhibits? How much time do you need to mark up
So
7
I'm going
exhibits?
to bring the jury back in. I will tell them,
Get out your
to get
black
out of here until
highlighter and
noon.
go. Let's move.
Sorry for the trouble.
no, it's the art of the possible. Let's bring in the jury.
Someone get out a Sharpie and start marking shit up.
Jurors enter.
Okay, please be seated, members of the jury. I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct?
No one approached you about this case. Is that correct? And you've not seen any media about this case. Is that correct? Okay. Let me tell you where we're at. And this is, again, that 5-minute issue my wife so much loves. I'm going to send you away to be back, go to lunch, and be back at noon. We're going to finish the evidence this afternoon and I am going to do everything I can to also give you the jury instructions this afternoon, which means that the closing arguments will not be today, but will be first thing tomorrow morning. When you come back, I'm going to see if you might be able to come in a little bit earlier tomorrow. But I intend on getting the jury, the case tomorrow, deliberations to begin tomorrow. So what I'm asking is, when you come back from lunch, are you going to be able to be here at such a time so I can basically start having discussions at 8:30 with the jury? Okay. So basically seeing if you can be here 30 minutes. I don't know. Just let me know if that's going to be a problem. If it's a problem, then we'll do it at 9 o'clock. So just let me know when you come back. Other than that, we are going to keep working today, and we're going to have information to you at noon. So I'm going to send you out, let you go to lunch now, and be back ready to go at noon. Do not discuss this case amongst yourselves. Do not do any investigation, and receive no information.
All rise. Jurors exit.
Yeah, so it looks like we're going to be signing off here ourselves for an hour or so, because there's nothing to do till noon. They're just marking up stuff, so I'll just wait for that to be confirmed, and then we'll probably sign off for the morning and try to come back at noon so we can hear this testimony today, because I'd love to give a recap on it this evening.
Okay, the jury's out of our presence. Everyone please be seated. Is there anything else about the exhibits, or can we pivot at this point to Mrs. Cross?
There's just one.
Why don't you discuss the juror issue as long as you're faffing around for a while? Why don't you discuss that for as long as that's going to take?
Can you just put it up?
It's okay, I'll find it. I found it, Judge. So 2817.
Page 9, please.
And the phrase is in here on several pages, but I think whatever ruling you make will apply. At the top there, Judge, it says, the second paragraph, there are 4 major areas we're actively working to improve. My issue was the second line, having had knowledge of complaints that allege a lack of oversight and accountability. I just thought that was probably referencing the Hart Institute. It's vague, I get it in general, but that was the one issue.
I am fine, since there's not a specific reference to the Hart Institute. I would leave in oversight and a lack of oversight and accountability.
Okay, that was the only, I think, disagreement on that document. Okay.
How many lawyers does it take to mark up 7 documents? That's what we're doing right now. How many lawyers does it take to mark up 7 documents?
Mr. Altenburn and Mr. Elliott, can I have you both come forward and let me spotlight you there, Mr. Elliott. I'm pulling up the...
Can we have the motion on disqualifying the juror so that I can move on and ignore it, please? That's what I'm thinking right about now. Or can I just say the motion is denied and call it a day?
Who wants to start talking first?
The biggest concern I think that I have at this point in time is the confusion over count 14 and the motion that I filed this morning about whether or not
The negligent training.
the negligent training count.
And you have now seen my...
I've seen, if it were to be removed, what you did appears to me to be the way to do that, yes. But I was quite, I put that in there purposefully, but I also knew that you'd ruled against me on the motion to dismiss on those issues, and so I wasn't 100% sure whether you left it in on purpose or whether this was just an oversight, and I didn't want to get carried away on this. But I continue to believe, as I always have, that this tort requires the person be outside the course and scope of employment, or that there be something exceptional. And all the cases that I showed you under the 766-110 statute were in that nature. The federal cases because the federal government is not liable under a respondeat superior, always have to have something additional by the government, and frequently that's negligent training, which doesn't come into play here. And so, I mean, all that line of cases struck me as meaning that, in fact, the person, if the person is in the course and scope and we are vicariously liable for them, that this does not play in. And, you know, when we get then to the damages, I think we all agree that the negligent training in and of itself doesn't cause impact or damage. What it does is it integrates with an employee who does something that causes injury to Maya Kowalski, which is the false imprisonment, the battery, or the medical negligence. And for the life of me, I think at that point the damages are 100% overlapped. I was concerned that the jury might not fully understand that, so I took the unusual step of actually asking for a nominal damages instruction on this so that they could give $1 or something if they couldn't figure out what else to do. But I just continue to believe that this count from its inception has been something poorly pled and not legally recognized in Florida. So I still believe that I should be entitled to a directed verdict on this count. But if not, then I'm not quite sure what we do with the instructions. If they insist on having it in, then it gets complicated with scope of employment, or, I mean, as I've said at the end, push to shove, I'll just have to withdraw this because everybody wants this case to go to conclusion. And I would rather have it resolved first so that it doesn't create reversible error.
Okay, before I forget, let me, Madam Clerk, on the question of directed verdict on the claim of negligent infliction of emotional distress. This is the one that I dealt with on Saturday.
Correct.
The transcript and the court minutes need to reflect that based on the court's rulings with respect to the physical impact requirement and the fact that I've ruled that death by suicide cannot qualify as a physical impact for the negligent infliction of emotional distress. Based on that ruling, that means the court's going to have to grant a directed verdict on the negligent infliction of emotional distress, and I do so at this time.
Wow.
And the lawyers know that I've done that, and we've already oriented our jury instructions in verdict form. I just needed to do that.
All right, so the negligent infliction of emotional distress case count was just dismissed?
Okay, going, Mr. Elliott, or actually Mr. Altman, was there anything else you wanted me to say as relates to the negligent infliction of emotional distress?
No, Your Honor, I guess I would point out that I had made these arguments in DIN 3396 was the last time I made them, which kind of ironically was entitled a motion to resolve critical jury instruction issues prior to opening statements.
I'm just pretty slow, Mr. Altman.
So Johns Hopkins
Mr.
won
Elliott, on the negligent infliction of emotional distress, anything else you need to say about the plaintiff's position before we move on to negligent training? You're on mute, Mr. Elliott.
Your Honor, I think you summarized it. We exchanged some emails over the weekend that are, I think, Mr. Alderman and I have discussed filing a set of the, the various instructions with the comments in it at some point so that they're there. But I think, as you accurately recited,
ID is still in, but any ID is out.
We understand the DB.
Now, let's shift gears and talk about the claim of negligent training.
Yes, Your Honor. I think I heard Mr. Altman.
I'll give a summary at the end. I'm still trying to listen to everything.
Other claims, it's not just medical malpractice, it's some of the others as well, and we don't dispute that. And it may be that there are not additional damage, there will be nominal damages. But we have briefed previously that we don't think this is limited to somebody being outside the scope. If, again, and we've had this discussion before, if the defense either agrees or the court rules that we can still talk about training in the closing, then I think we're probably don't need it as a separate count. But if we're going to face opposition on that, we think it should stay in. If the court decides later on as a matter of law in terms of reviewing it after the fact, assuming the jury even does anything with it, you can always direct it out at that point, but at least we'll have gotten a ruling on it. So those are sort of two alternatives that we would suggest.
Mr. Altenberg.
I mean, the only thing I would suggest about their proposal on can they talk about it, then the question becomes, well, I don't disagree they can talk about evidence that's relevant to something that's left. From listening to the discussions this morning, there may be some element of this that relates to a punitive damages claim. I'm not exactly sure how that ties in, but it doesn't really have anything to do with whether someone commits one of the other torts that we're vicariously liable for, because they're intentional torts that if Ms. Beatty made a contact that was offensive and not such under intentional tort law, then it doesn't really make much difference about whether she was perfectly trained or not perfectly trained. And the same is true for the false imprisonment. And the medical negligence stuff is a whole different can of worms, because that's supposed to be a professional standard of care. And we're going right now to the jury on negligent training on an ordinary standard of care for a medical facility that is itself deemed to be a healthcare provider, is now under an ordinary standard of care to provide training to another healthcare provider. I don't think that's the law, and I think we're better off getting that count out of there. And again, if there are things that are relevant that are left from this testimony that can be used for the rest of it, I can't object to relevant testimony.
How does this ruling impact, if at all, what we're talking about rebuttal?
You know, Your Honor, I was not in the courtroom when this happened, so it gives me a slight disadvantage, but my impression is we were talking about this in significant part related to negligent training and trying to show that we had accreditation. What I don't honestly know myself is whether that carried over to something that relates to the punitive claim. But the punitive claim really is whether or not the people at the high level, the officers, directors, or true managers, were so involved in something that they become liable, or whether they were in a posture where they fit into one of those other two categories. And as you point out, it's kind of a two-edged sword for them, because it has to go up to management to be ratified, or go up to management for them to make a decision on it. And their whole line of theory here is that nothing went up the chain. So I've always kind of listened to this with the same interest that you had, that I'm not sure how it ties into punitive as compared to training, but I'm not going to tell you that I'm 100% convinced that there's not, as you use the word scintilla, of evidence of this that somehow relates to punitive damages.
What about, hold on one second, Mr. Elliott. What about Mr. Elliott's, or maybe it was your initial idea of just putting a nominal?
I only did that truthfully as a last resort, because nominal damages are supposed to be for a tort for which damage is not an essential element, and damage is an essential element for the tort of negligence of any variety. So here, there's at least nothing new in the way of damages for this tort compared to the two intentional torts and the medical negligence claims that are the predicates for this. So I'm doing that only because it seemed to me to be the best way to protect the verdict from getting some, now that I know that how much money they want to be seeking, some large number for something that doesn't really have any damages.
Mr. Elliott, anything further?
Yes, Your Honor, a couple brief things. Not correcting something, not training, not correcting, is condoning. It is ratifying. So it is relevant to the punitive damages. And I heard a reference just saying, well, I think this is relevant here. Something about it, not being reported up. Well, wait a minute. Not reporting to the national headquarters is not the issue. Sound like they fired the CEO of this hospital for what was going on there. That's high enough up. That's punitive damage liability of the hospital. That's who we're talking about here. The fact that they're owned by somebody else or overseen at some level by somebody higher up, we don't have to get there. Firing the CEO because of how bad this was kind of makes the, is relevant to the punitive damage case.
I've been warming up to Mr. Altenberg's position on this. I wish I felt as confident as you seem to feel about this claim. And is there any way I can leave the claim in with shifting a question or two, so that if I felt like after the fact I need to DV it or JNOV it, I can? I mean, I want to make sure that the law is correct and the instruction's correct.
My concern, and it's kind of for both sides here, is that at the beginning of this trial, the understanding was that we weren't going to shift to somebody outside the scope and course of employment. So they didn't put on any evidence of that. And frankly, I didn't raise that anyone was outside the scope and course of their employment, because in good faith I didn't see any evidence that I could use as the defendant to try to prove my employees were outside the scope and course of employment. So a shift to that has the questions that I put in the motion this morning, where we have to individually say, well, somebody outside scope and course. I don't think we need or should do that, because I don't really think there's any evidence of that in this case. If in fact there's no evidence of damage beyond the underlying torts, I don't see how it can possibly be harmful error to omit this, because the damages are going to be the same one way or the other. There's not going to be any harm to the plaintiff done by omission of that. And Mr. Ellicott's made a good point that some of this may still be relevant for punitive. I'm not saying that that's outside the zone here.
Your Honor, if we could... Oh, sorry.
Go ahead, Mr. Elliott.
I would say if we can have an understanding or agreement or a ruling that training can be discussed in closing, I think we're there. And having heard a preview of the closing, it's not a feature. I mean, if there's a reference or two, I actually missed it. And Ms. Ferrier heard it. I think she heard it. So it's not going to be a feature.
I haven't heard that. I didn't have a chance to hear the feature. I guess my inquiry would be, is it relating to punitive damages, or is it relating to something else?
I couldn't tell you the context.
Yeah. Okay.
What about Mr. Ellicott's, if there's some sort of understanding? I made so many calls in this case, and I think this is pretty much my last call.
I'm essentially conceding to you that I think there's a level of this that could be talked about for punitive damages, and whether Mr. Anderson will go farther than that line, I don't know, but there certainly is a line there that he can go to. So.
I think I need to ask Mr. Anderson to make sure I'm not giving away something, if he's comfortable with what we've talked about.
This much I know for certain. There is a plan behind everything the defense does. And because of that, I would like for it to go to the jury and for the court to then consider these matters on JNOV. If we have to ask an additional question, we're not opposed to that. But as to the cause of action, we would prefer for it to go to the jury. And the court hasn't heard the conclusion yet of one of our witnesses.
My evil plan is simply not to have one more claim on the verdict form and to have to deal with it in closing arguments, Your Honor.
Well, Your Honor, you have to make a call. Is it in or is it out?
Mr. Anderson, I hear you want it to go, but like I said, I'm starting to really warm to Mr. Altenberg's position that it might be legally incorrect to let it go to the jury, that the negligent training has to be outside the scope.
Isn't that an issue for the jury, Your Honor?
Well, we don't have a jury finding currently itemized on the verdict form, and based on how this has been developing over the last 9 weeks, it's not something that really we've been focused on.
I would remind Mr. Anderson that if they're outside the scope for count 14C, then they're outside the scope for false imprisonment and battery, and that impacts his punitive claim itself.
My concern is I do not want to hear from the defense after the court rules some argument that somehow our punitive damage claim is inadequate or we failed to preserve some issue. And sure as sure, we're going to get that from them. And so that's why unless simply submitting it is reversible error, in other words, if the court afterwards determines on J&OV to take it out, I don't see the problem with submitting it and getting their view.
I think Johns Hopkins
is right. Except it allows for a chunk of argument on things that probably should never have come in. I mean, the problem with if there is, as he says, a strategy, but I've been worried about trying to sort out the negligent things that the jury has heard about compared to the things that were extreme and outrageous conduct with intent. And
I guess, and this is going to sound pretty callous, I don't really care what your all's arguments are.
Good.
It's a question of what I legally have to do.
Right.
And that's, I just wish I was over the finish line on this issue where you seem to be, Mr. Alton-Brown. I'm just not quite there yet. I'm pretty close. I've warmed to the idea that you might be correct on it, but I'm just not over the finish line on it. And so that's my hesitation.
But your hesitation is on it as a legal issue as compared to the evidence that's going to the jury. So, I mean, it's not like the directed verdict is dependent upon whether there's evidence on this or not. It's whether this claim can be made by someone when there's absolutely no dispute that it's going to be 100% covered by the employer because the employer is vicariously liable. And that's, the cases that they've cited to us just don't fit that. And the little case law under 766110 doesn't seem to fit that.
And I guess my concern is, let's say there's a finding of no liability on false imprisonment, battery, medical negligence, and then there's a finding of liability on negligent training.
So how could that be? Your current instruction says that cannot be.
And that's, right? If your argument and your position is legally correct, then how can that be? I think that's the appropriate question.
And that's how you have it currently on the verdict form that you submitted to us last night. They can't answer the questions on negligent training unless they answered yes to one of those questions at least.
Mr. Elliott, I'll give you one last chance. I am, like I said, I'm more in Mr. Altenberg's camp on this issue than I am in your camp. So
I'll explain this when we get to the end of this. I'm just waiting to see how it pans out.
Concerns, and I don't know that I have anything to add. I mean, again, I think part of the problem could be addressed as long as he's not going to be interrupted when he starts talking about training because it is relevant.
If it is wrapped at some point into the med-mal, which is what I thought we were going to do about 2 months ago with this. But as long as it's wrapped in so that my concern is not fulfilled, then I understand the need to streamline. And, of course, the law.
I'm not quite sure how it's wrapped in at this point to the med-mal. We've got those instructions are kind of what they are.
there any question, Mr. Altenburn, that we could ask that lets me basically punt on this issue?
Judge, it's a question of law. It's not a question we can ask the jury. I'm sorry. I wish it were.
Mr. Elliott, any other question that I can punt on this issue?
No, I think if the concern, one of the concerns I heard earlier was, well, you have to have med mal to answer this question on the medical malpractice part. I think you could add a line that says that. You could say, well, let's put it this way. Yes, I think you could answer a question. You could add a question that says, if you find that the training was inadequate for a healthcare provider, you would need to answer do the analysis you did above for the medical malpractice claim.
I mean, they're already going to be able to argue that whoever breaches the standard of care on diagnosis and treatment did so because they weren't adequately trained or because they fell below the standard of care. That all fits together in that package. I mean, but it's the standard question in this situation about these doctors and whether or not they deviated from the medical standard of care in treatment or diagnosis.
Yeah, it's subsumed by the other issue.
It doesn't create another spare question.
Yeah.
I think I just heard what we've been asking about, which is that we can talk about this may have happened because of a lack of training.
Yeah, I think Johns Hopkins is right.
I apologize, but if I heard that, I think that may satisfy Mr. Anderson.
And can we hear the end of Dr. Corcoran's testimony before we make any finals?
Well, I guess the answer is yes, but all this has to get printed. All this has to. It's going to take
Rubio,
a while.
good to see you. Hope you're doing well.
To make that happen. And so I'll be having the jury sitting, cooling their jets even more.
Talking about this afternoon with jury instructions.
Right, because I mean, I got to print them out. And it's, I've got 11 or 12 jurors, depending on how we deal with the juror disqualification issue, plus all of y'all, the court reporter and me. And we're talking, close to 75, 80 pages per. Okay.
It's wild.
Mr. Elliott, I guess I've always kind of, I don't say that this has been a throwaway count, but it just kind of seems duplicative of the other counts. And I think at this point, even though I'm not fully on board with Mr. Altenburn, I'm more on his side on this one, and it just seems like it's cleaner to not have the negligent training questions in there. I think from a percentage odd standpoint of me being wrong, I've got less of a chance of being wrong on that than if I leave the questions in.
Your Honor, and I think, again, our concern, including Mr. Anderson's, and I think we heard it would be okay as long as you can talk about training, and again, it won't be a feature of the closing, but as long as you talk about training in the closing, and it is relevant to several issues, then I think...
It is relevant to several issues. The problem is whether or not it's a standalone issue, which is what it's being charged as.
Shrug meaningful to this discussion, or...
I mean, not particularly, Your Honor.
Yeah.
Honestly.
Toss the count.
Just to be honest, it's not a feature of my closing either.
Yeah, toss the count. Make it cleaner. Toss it.
Okay, well, this is where I'm at. I think I'm going to remove the negligent training question. I've heard some discussions, and I do agree that the question of training does go to the other tort counts that are existing. So I think we're really talking a lot about something that's not going to become an issue or should be an issue. Certainly, it also goes to the punitive damages. So I think I've got a greater chance of being correct by not asking the negligent training questions and removing that from the verdict form. So I'm going to say let's go with the version of the instructions and verdict form that I circulated this morning. And now, knowing that that's the version I'm going with, have you all had any chance to see if I've messed up the cross-references any?
Well, I confess that I've read this document so many times in the last 3 months that it's hard to proofread, but I didn't see anything that was a mess up on it. But the only other thing that I'm still a little concerned about, especially after I saw the calculations, which seem to be mathematically correct, is that there are lump sum for all non-economic damages, which when we get to non-duplication with the concept the pain and suffering must be for this tort, this tort, this tort, it's going to make it even harder for the jury. And so I know that you think your non-duplication instruction is adequate, but I think it's going to be tested by the closing argument.
Yep, it's going to be difficult separating all this out.
I proposed something, but you didn't get it. So.
There's so much that's been tested in this case, Mr. Aldenberg. What is one more issue?
It's a veritable fertile field, isn't it?
Okay. What I would ask is and I don't know if it's Ms. Ferrier and somebody else in your office, Mr. Altenberg, to go back and fly spec
this,
especially the cross references. I'm going to start having printing of the verdict form and the jury instructions, and if we have to throw those away and change them, I've wasted some paper. But from a timing perspective, if I can not have the jury continue to wait on me, then...
And on that verdict form, I guess all of the negligent training's out, so the one question we were uncertain about is gone. Okay, yes.
And I mean, I'm not saying that you and Mr. Elegant shouldn't look at it, but...
no, fresh eyes would be a good idea.
Eyes. And honestly, I think I'm probably in the same boat that you are. That, I mean, if I had 4 days to put this aside and come back to it,
right,
I would do that. But
thank you, Lynn, for the super chat. Appreciate it. First super chat ever.
Sure.
That's very kind of you.
I'm
glad that I received your first super. That's very nice.
Anything else that we can do before noon, or I should let y'all take your time, finish out these exhibits, and be ready to go at noon?
Your Honor, what time did you want to talk about the juror issue?
Can we just do that after we send the jury home today? Is that
yes.
problematic for anybody?
No.
So defense, you're okay with just waiting until?
That's fine, Judge.
Okay, let's do that after. Let's take that one off the table until we get this rebuttal case nailed down.
Can we come back at 10 till, just in case Ms. Crawls has any further requests for minor redactions?
That's fine. 10 till. Now, one other thing, and it probably doesn't matter since you have a lot of technology, but I was going to give the lawyers a copy. Sometimes the lawyers want them stapled, not stapled. Sometimes they want it two-sided. Sometimes they want one-sided. Is there any specific request?
This is funny. We're arguing over how it's actually physically going to be printed. This is cute.
Instructions in verdict form.
We like the stapler. One-sided or two-sided is up to the court.
I don't care about the stapler. It's just the TV, doing it right in front of the microphone.
I know. We'd appreciate a staple.
Stapled, and if we could, just one side.
One side.
I insist that you use a red stapler.
It can be done.
It must be red stapler.
Do you want yours?
And the staples themselves be colored? Is that possible, Your Honor?
Okay. So does that go for your entire team or just you?
I think Ms. Crowell is partial to one side.
And Madam Court Reporter, I'm going to get you a copy. Do you want yours one-sided or
Your Honor,
two-sided?
we've been seeing a lot of white paper in this thing. It's a little bit hard on the eyes. Can we get maybe a soft
And
yellow
Mr. Elliott, your team
for backgrounds? A little bit easier to read. Maybe a goldenrod would be nice.
From when they come out off the.
Also, I'm not really that much fan of Arial.
Thank you.
Could we get this printed and
With that, let's be back here. at
Garamond or
11:50,
something? That'd be good.
11:50. Okay. We're going to rock and roll.
All right, fine. So now that that's all over, I can summarize where we are as of this morning. Fantastic. All right. So here's a summary of this morning's session. We had a lot of argument on the whole rebuttal testimony because Johns Hopkins' lawyer got on the stand. Well, not their lawyer, I'm sorry. Their witness got on the stand. That was the word I was looking for. Their witness got on the stand and said, Johns Hopkins is a great hospital. They have no problems with anyone. The regulatory authorities love them. They are great and wonderful and a drop of light into the world. And plaintiff's counsel is all over here like, we don't think that's true. So could you produce, all the records and reports and stuff that basically would, kind of demonstrate not that? And then this morning, we got Johns Hopkins whining about the whole thing for a long time. And then Johns Hopkins said some weird things. They said, first of all, that their witness didn't say anything that was factually wrong. Their witness was correct. Our witness was talking about the relevant time period, Your Honor, that Maya was there. And during the time period that was there was no problems. That's what they meant. And also, we'd like to strike our own witness's testimony because it's really bad for our case. And the judge is over here like, but they said things that were true. So why would I strike it? And Johns Hopkins is over here because it's bad for our case. And then plaintiff's counsel over here, in what was potentially an unforced error, said, yeah, motion to strike works for us. We also want a corrective instruction. Also, we still want rebuttal. And the judge is like, yeah, you can't have both those because that doesn't make any sense. And the judge is absolutely correct. It doesn't make any sense. You can't have both those things at the same time. All right? If I grant the motion, so basically the judge is basically saying to plaintiff's counsel, are you sure you want to do that? And then Johns Hopkins, I don't know, doesn't notice the complete unforced error and doesn't leap on the football like the fumbled football it is for some reason. Johns Hopkins apparently doesn't notice that counsel over here has fumbled the ball and doesn't leap on that thing like dear life and say, yeah, hey, plaintiff counsel themselves said motion to strike was fine by them. We couldn't agree more with plaintiff's counsel. Plaintiff counsel is smart counsel. They're the greatest counsel in the world. They said motion to strike. We couldn't agree more, man. We are so thrilled for that. We endorse it all. Plaintiff's counsel is best counsel. They didn't say any of those things, apparently missing the opportunity. And instead we're like, so Johns Hopkins is over here saying some stuff because they don't notice the unforced error. But the judge notices the unforced error and is like, are you sure? Can't help noticing there's a football just, sitting there on the middle of the field and I haven't, blown the play dead. So, would you like to maybe do something about that? That the football's just sitting on the middle of the field and the play hasn't been called dead and you guys are just standing around. Would anyone like to, pick up the ball at any point? That would be great. So he's like, you can't have both these things. You can't have both the motion to strike the testimony with a corrective instruction and also rebuttal based on the testimony that now no longer exists. That doesn't make any sense. You can't have rebuttal unless there's testimony, but you want to strike the testimony, at which case there's no longer testimony, so you can't have rebuttal on the testimony that now no longer exists. Because that doesn't make any sense at all. If I strike the testimony and I give the corrective instruction, then as a matter of law, we believe the jury will disregard it because we tell them. And juries obey the law, don't you know? Of course they do. So as a matter of law, if I say, okay, the testimony is struck, jurors disregard, then the testimony never happened. We have unrung the bell, and now there's nothing to rebut. So, which would you like, counsel? Which would you like? Would you like what's behind door number 1? Where I strike the testimony, give the corrective instruction, and don't allow rebuttal on the now non-existent testimony? Or would you like door number 2, where the testimony remains on the record and you get rebuttal. And then apparently they had to have a think about it for a while, for some reason. And appellate counsel, who's also in the room, which is kind of hilarious, they had a 5-minute powwow about which of these doors do we like better, even though the answer seems inherently obvious. And they say, after discussing it, after discussing it with our coaches on the side of the field, while incidentally the play is still live. So in our football analogy, both sides go off to the side to have a powwow with the coaches, not by calling a timeout, mind what. The ball's just still sitting right on the middle of the field. There is no dead play, but we're gonna just go off to the side of the field and talk about it for a while. The ball's just sitting right there, okay? After coming back, plaintiff's counsel's like, you know what? We would like to take possession of the ball. We think that would be good. We'd like to take possession of the ball. How about we don't strike it, and how about we have rebuttal? And the judges think to themselves, good decision. So we're going to have rebuttal. All right, then there's a whole thing about what is the rebuttal going to be. And the judge says, okay, what I want is, I want a really high-level discussion, okay? I don't want to get into the weeds about, the many, many misdeeds of Johns Hopkins in whatever cases that they have in their long and illustrious history, okay? This is a case about Maya Kowalski. We are not turning this into, another dozen mini trials about, whether or not Miss Smith, whoever Miss Smith is in this analogy that I'm making up, Miss Smith doesn't exist. But let's pretend Miss Smith exists. We're not gonna get into a discussion about Miss Smith and her heart stint, about whether or not Johns Hopkins gave her the right stint or not, or blah, blah, blah. We're not getting into the case of Miss Smith and Miss Jones and Miss Rowe and Miss whatever, right? We're not doing that. We are not getting into the weeds of, every issue, and turning this from, let's discuss every med-mal case individually, and let's have another discussion about each of them. Let's not do that, says the judge. I agree. Let's not do that. All right, so what I will let you do is I'll let your expert on the stand for 3 hours, and they can talk about it, and that time includes cross, by the way. So basically, you can have your expert on the stand, and here's 2 boxes of stuff, and what would you like them to talk about? Please tell me. And apparently they're ready to go. They don't need time to look through the boxes. They already know this. And they're like, okay, Your Honor, we'd like to discuss these 7 documents. And right away, the lawyer in me was very pleased, because they didn't overextend their welcome, right? They didn't say we'd like to discuss these 700 cases or 700 documents, right? They didn't overextend their welcome. It's like, we've narrowed this down. We've narrowed this down to a choice 7 documents. These are the documents we'd like to discuss. Only these documents during rebuttal. And I immediately was very happy because they understood the assignment, right? The judge says, I would like to discuss this at a really high level. I don't want to get into the weeds. They say, we'd like to discuss 7 documents. I'm like, that is the right answer. You understood the assignment. You got it, right? You understood. I don't want this to go on. So just these 7 documents, great. Then we had an argument about what is included in the documents or not, exactly. And I guess from context, we're crossing out any references to the Heart Center specifically, and any specific references that deal with anyone's deaths, because, too prejudicial. And also, we don't want to get into the weeds about these other people. And also, we don't want the jury deciding we don't like the death of Miss Smith, Miss Jones, Miss whatever very much. We don't really like those deaths, so we're going to punish them for those deaths. That's not what we're here for, right? We're here for Maya, not for Miss Jones. Miss Jones can file her own lawsuit. Maybe she has already. But either way, we don't want the jury getting into those cases. So we'll strike any references to any deaths. We'll strike the references to the Heart Center. You can bring in the documents. Then they were dicking around for a while about exactly what the redactions were, because apparently they were having a pissing contest about that for a while, about exactly what the redactions would be. And it's like, we need another hour or something to do the redactions, so it's like, So after deciding where exactly the block highlighter goes on these documents, which apparently that issue is resolved, I think, then we had some motions for directed verdicts, which were granted. So we dismissed the count against Johns Hopkins for negligent infliction of emotional distress. The intentional infliction of emotional distress claim still survives. The negligent infliction of emotional stress claim is dismissed. Negligent infliction of emotional distress requires a physical injury. Okay? Intentional infliction of emotional distress does not require a physical injury. Negligence does. Intentional does not. All right? So we must have a physical injury. All right? And the judge had previously ruled that the death of Maya's mother cannot count as a physical injury. We've already discussed this issue as to why, for many, many legal reasons that we've discussed. So the judge says, okay, you can't use Maya's mother's death as the physical injury, and then apparently rules that there is no other physical injury in the case that can qualify. So after 7 weeks of testimony, and we're at the bitter end, right? We've heard all the evidence, because we're in the rebuttal case. We've heard all the evidence. So it's like, I've already ruled that Maya's mother's death can't qualify. There is no other evidence of physical injury that derives from a negligent infliction of emotional distress, right? There might be physical injury that derives from medical malpractice. There might be physical injury that derives from battery. There might be physical injury that derives from this, that derives from that. But there is no physical injury in the record that derives, that is caused by a negligent infliction, okay? So therefore, there is no physical injury. Therefore, the cause is legally dead. So the cause is therefore stricken, directed verdict. So it disappears. Fantastic. Then we had a separate count as to basically negligent training, failure to train, as a separate count. And Johns Hopkins is over here like, okay, this doesn't really quite make sense. And also they can't find, first of all, they can't find it unless there's an underlying injury, right? Unless something happened, you can't sue them for the failure to train, right? Because it only matters, the negligence only matters if there's a damages. That's in the nature of negligence, right? You need duty, you need injury, you need causation, and you need damages, right? You need duty, failure of the duty, you need causation, and you need damage, okay? So you can't sue them unless there's damage, right? The negligent teaching, the negligent instruction, the negligent teaching only matters if damage occurs from that. But you already have those damages built in somewhere else, right? You already have the count for battery, you already have the count for false imprisonment, you already have the count for whatever, right? So Johns Hopkins is over here like, how do we separate out the damages? Assuming damages occurred, what are they? And are they not simply duplicative of other damages? Right? Because we need to make sure that the jury is only issuing damages for the things that they're damages for, which is also a fun thing. Like, how does the jury separate out the damages into their component parts? How much for this, how much for this, how much for this, how much for this, to separate them out into their subparts? So it's like, okay, they literally can't decide this cause of action unless they find the other cause, at which point, like, what damage is there? Because the damages, to the extent they exist, are in that cause of action. They're in the battery, they're in the med mal, they're in the wherever, right? There's no damages that are just kind of existing in the ether from failure to train. So it is merely duplicative. And it's like, how about nominal damages? How about $1? And they're like, well, no, that doesn't make sense because nominal damages would only be a thing if damages were presumed by law, which they're not in the case of negligence, right? Nominal damages would be a thing if we were talking about per se, like defamation, for example, right? Damages are presumed by law. So if you don't prove damages at trial, what do? You get $1. That's nominal damages, right? Because damages are presumed. So if you never prove damages, you win and you get $1. But you only give nominal damages if they're presumed at law. And there's no presumption of damage. So you can't award nominal damages. That doesn't really make sense. And you can't award any damages that are severable from the underlying injury. So that doesn't make sense. So after dicking around for that in a while, the judge agrees with Johns Hopkins, and I think the correct call is like, I don't think this works legally. It's simpler and cleaner if I get rid of it. So let me get rid of it. So that cause of action disappears. So Johns Hopkins won a little bit today. So good for them. They're still lawyering. They're still lawyering up to the bitter end. It probably won't matter very much in the end because I'm sure Johns Hopkins is going to lose big. But they're trying, right? They're trying to eke out whatever little edge they can at this thing. And that's fine. If they're right, they're right. You know, just because Johns Hopkins is literally the devil doesn't mean that they don't get to win. because the law binds us all equally. So that's fun. So that's where we're sitting on all this, right? So when we come back from the lunch break, we're finally going to hear this rebuttal testimony. So that's exciting. And then they were arguing about the jury instructions for a while because, which set of instructions do we give? So we give the instructions without the cause of action. And they're like, can you please cross-check it to make sure it's, correct? And they're like, we'll give it a shot. So, yeah. So the negligent infliction of emotional distress was dismissed, and the negligent instruction, I believe, was what it was phrased as. Negligent instruction, which is failure to train, failure to supervise, blah, 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 whatever. So, yeah, you can still talk about all those things, by the way. So they're not saying you can't talk about those things. You can talk about those things. You can talk about them in close. It's just not a separate cause of action unto itself. It is relevant to med mal. It is relevant to battery. It is relevant to false imprisonment. So you can still talk about it. It's just not a separate cause of action. It can't exist by itself. It is part of some other case, not a case unto itself. So that's where that's it. So, great. Motion to remove juror number 1 is still pending. The judge has deferred that until the end of the day. So the motion to remove juror number 1 is still pending, and we will hear from that at some point later. So yeah. Yeah, most of the claims are still on. This is just stuff around the edges. This is just stuff around the edges, guys. So it doesn't really matter very much in the grand scheme. I mean, it's not like you don't fight for everything, because of course you do. Of course you fight for everything for your client, right? I mean, you don't want them to have liability that they don't have to have, so of course you fight around the edge, but in the end, it just doesn't matter very much in the grand scheme. Although it does make it a little bit cleaner for appeal, which is nice. So that's plus. Yeah. Yeah, I did a discussion of the motion to remove and the reply, and I mostly laughed in Johns Hopkins' face. That was my legal analysis, was mostly laughing in Johns Hopkins' face. So I read their motion to remove, and I laughed in their face. And then I'm like, well, I guess we can also read the response, although I've already decided to laugh in Johns Hopkins' face, so I'm not sure what more they can do, because I've already decided that Johns Hopkins is wrong, but let's read it anyway. So we discussed it. I laughed pretty hard. I was like, no, you can't remove the juror. They didn't do nothing wrong. I'm really sorry the jury doesn't appear to like you. But the juror didn't do nothing wrong. So my response was mostly laughing in Johns Hopkins' face. And I felt it was a very desperation move. So, yeah. So I'm going to take a break for lunch. But I will go ahead and schedule that so I can send you to my own stream. But yeah, let's talk for a little while while I'm scheduling. We'll be back at noon. And I have to rename this, I guess. Taking care of Maya, I guess we'll call this rebuttal case. And I have to rename this morning session at some time. Yeah. So my response was mostly laughing in Johns Hopkins' face, which I feel is exactly what Johns Hopkins deserves, to be quite honest. Oh no, juror number 1 is asking questions that we don't like. Oh no, their questions are really mean to us. We don't like it very much. Why won't they stop asking us mean questions? We don't like these questions. They're mean, and they're mean to us. So yeah, that didn't really do much for me. The jury is sitting, and they don't like you. So yeah. Yeah, the questions were so mean we can't even quote them in our motion. That was cute. It's like, yeah, they're so mean we can't even quote them in our motion. That's how mean they are. Yeah, when you're like the jurors' questions were real mean, and you don't even quote the questions, it's not going great, I have to say. Yeah. All right, friends, I'm going to pause for lunch. We will be back in 30 minutes so we can hear some of this rebuttal case. I'm looking forward to it. It's fun and interesting. This hopefully will automatically redirect you to this afternoon stream. So I appreciate the 540 of you who are currently here while I get a little lunch in my stomach. I look forward to part 2 of this thing. This is fun and interesting. We'll see how it goes. So we will sign off for now. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.